Matters of which year? Huh? Fresh matter. Huh? When did you file? When did you file? Date? Please go and ask in the office. Yes. There is no scope for moving a memo offline now. You have to meet online. ಆಯ್ತು. ಹಾ. ಹಂಗಂದ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಮುಂಗ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. ನಾಟ್ ಪಾಸಿಬಲ್. Sir, all arrangements are made to receive your application online. See, we want to avoid all this problem. That is why we are coming up with this system. Again, you are coming back to the same old system. What is the use then?
Ideally, excuse us for at least a week or 10 days so that we can adjust to it. Ideally, excuse.
No, ದಯವಿಟ್ಟು ಆಫೀಸ್ಗೆ ಹೋಗಿ ಅಲ್ಲಿ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಅಂತ ಕೇಳಿ. We have given instructions. See, this is a pilot project. We have started off only with a few courts. We want to see how it works. If there is any difficulty, you please go and mention in the office, or after the court hours, you please tell the court officer. He will look into it. Agboda? Yes. ನೋಡ್ರಿ ಅದೆಲ್ಲ ಮೂವ್ ಮಾಡಿದ್ದು ಬಂದಿಲ್ಲ ಅಂತಂದ್ರೆ ಏನಕ್ಕೆ ಅಂತ ಸ್ವಲ್ಪ ತಗೊಂಡು ವಿಚಾರಿಸಿ ಪೋಸ್ಟ್ ಮಾಡಿಸಿ. ಎಸ್. Of course, you please give it to the court officer. Let him look into it and yes. ಅದೇ ರೀ ಎಲ್ಲರಿಗೂ ಒಂದೇನೆ. You please bring it to the notice of the court officer. He will look into it. Yes. We will list it, sir. We have to list it in accordance with the system that we have put in place. Yes. Yes. Please wait. Yes. Other side is here. No adjournment. Withdraw. Serial number 23. Learned counsel for the petitioners has filed a memo dated 17/1/2024 seeking leave of this court to withdraw the writ petition as not pressed. Next paragraph. The memo is taken on record subject to all just exceptions. Full stop. Accordingly, the writ petition stands dismissed and withdrawn. Same order. Seeking leave of this court to withdraw the writ petition as the parties, the contesting parties have decided to settle the matter amicably. Huh?
One. I see.
Yes. Will. Endorsement ಕೊಡ್ತಾರೆ. ಎಲ್ಲಿದೆ? Where is that? Hmm. No objectors. ಗ್ರಾಮ ಪಂಚಾಯತ್ ಯಾಕ್ರಿ ಪಾರ್ಟಿ ಮಾಡಿದ್ದೀರಾ? ಹಂಗಾರೆ this is not a land revenue matter. If it is, no, if it is a property situated within the Gram Tana limits and you have approached the Panchayat Development Officer for change of Khata, then it's not a land revenue matter. Then why did you go to the Panchayat Development Officer? Huh? ಏನ್ರಿ ನೀವ್ ಇಷ್ಟ ಬಂದಂಗ್ ಮಾಡ್ತಿರಲ್ರಿ? 4 acre, 8 guntas of land. Huh? Then it is within the Gram Tana then. That is why you have gone to the Panchayat Development Officer. Please come to the will, schedule of the will. ಅದ್ ಹೆಂಗ್ರಿ ಬರೀ ಅಷ್ಟೇ ಅಷ್ಟು ಪೀಸ್ ಬರುತ್ತೆ? ಹಾ? Where is the RTC? Where is the RTC? Learned AGA takes notice for response number 1 to 3. Issue notice to respond number 4. The petitioner is also permitted to take out hand summons to respond number 4. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Full stop. Next paragraph. On going through the petition papers, it is not clear as to whether the property in question is an agricultural land or whether it's a residential site within the limits of the Gram Panchayat. Stop. Learned AGA is directed to secure instructions from the fourth respondent Tahsildar as to whether the land in question is an agricultural land or a residential site. Stop. Similarly, the learned counsel for petitioner is also required to clarify the position. Release this matter. On 29th of January.
Babu.
Form number 57, filed on 7/3/2019 at annexure B. Hmm? How did you put up the house? How? How, sir? Unauthorized occupation ಅಂತಂದ್ರೆ, can you put up unauthorized construction also? How do you mean not aware? ಏನ್ರಿ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ನೀವು? Your application is given only in the year 2019. You have filed an application under the Right to Information Act. Annexure K. Huh? Seeking information as to whether your application has been disposed of. ನೀವು ಅದ್ರ ಮೇಲೆ ಆದ್ರೆ you have to go to the Information Commission. ಏನ್ರಿ, what do you say? You will dispose of the matter with directions. Till the consideration of the application, you cannot do anything. Perfect. Learned AGA takes notice for all the respondents. Next para. The grievance of the petitioner is that although he filed an application in form number 57 on 7/3/2019 seeking regularization of unauthorized occupation of 4 acres and 38 guntas of land in survey number 82/P1 of Kelluru village, Mudgere Taluk, Chikmagalur district, the second respondent Tahsildar has not placed the same before the Committee for Regularization of Unauthorized Occupation, and no orders have been passed on the application till date. So, however, in the meanwhile, the second respondent and the other revenue officials are trying to evict the petitioner from the land in question. Stop. In that regard, representations have been given by the petitioner on 25/9/2023 to consider the application in form number 57 and pass necessary orders. Stop. Next para. Having heard the learned counsel for the petitioner, the learned AGA, and on perusing the petition papers, this court finds that there is sufficient material available on record to show that application in form number 57 has been filed by the petitioner in the office of the second respondent, Tasildar, Sulia Taluk, on 7/3/2019, seeking regularization of unauthorized occupation. Stop. However, if no orders have been passed on the application and without consideration of such application, the second respondent or any other revenue authority will not be permitted to evict the petitioner. Stop. In that view of the matter, the writ petition stands disposed of with a specific direction to the second respondent, Tasildar. ಇಲ್ಲೇನ್ರಿ ಅರ್ಕಲ್ಗೂಡು ತಾಲೂಕು ಅಂತ ಬರೆದಿದ್ರೆ ಅಲ್ಲಿ ಸುಳಿಯ ಅಂತಿದೆ. ಪಾಸ್ಟ್ ಟೈಟಲ್ ನೋಡ್ರಿ, ಏನ್ರಿ ಮಾಡ್ತೀರಾ ನೀವು? ತೋರಿಸ್ರಿ ಅವ್ರಿಗೆ. ಮತ್ತಿರಪ್ಪ ಹುಡುಗರು ಸುಳಿಯ ಬರೋದು ಚಿಕ್ಕಮಂಗ್ಳೂರ್ ಏನ್ರಿ? ದಕ್ಷಿಣ ಕನ್ನಡ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಅಲ್ವಾ? ಸುಳಿಯ ಬರೋದು ಇದರ ಅಲ್ಕನ್ರಿ, ಪುತ್ತೂರ್ ಹತ್ರ ಇರೋದಲ್ರಿ ಸುಳಿಯ. ಇದ್ ಬೇರೆನಾ? ಅಕ್ಷರ ಬಿ ನೋಡ್ರಿ. ಏನ್ರಿ ಎಲ್ಲ ಅಟ್ಟರ್ ಕನ್ಫ್ಯೂಷನ್ ಅಲ್ರಿ ನಿಮ್ದು. ಹಂಗಾದ್ರೆ ದಿಸ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇಟ್ ಸೆಲ್ಫ್ ಇಸ್ ಬೋಗಸ್ ದೆನ್. ಮತ್ತೆ ಮೇಲ್ಗಡೆ ಅವ್ರ ಲೆಟರ್ ಹೆಡ್ ಆದ್ರೆ ಅದ್ ಹೆಂಗೆ ಇದು ತಪ್ಪಾಗುತ್ತೆ? ನೋಡ್ರಿ, ಕನ್ನಡದಲ್ಲಿ ಮೂಡಿಗೆರೆ ಅಂತ ಬರ್ದವ್ರೆ, ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಸುಳಿಯ ಅಂತ ಬರೆದಿದ್ದಾರೆ. then this is bogus document then. ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ತೆಗೆದಾಕ್ಬಿಡಿ. However, the learned AGA points out to certain defects in the writ petition. Stop. The learned AGA points out to Annexure B, which is said to be an acknowledgement issued by the office of the Tahsildar, Mudigare. Stop. However, in the letterhead, in English, it is written as Tahsildar, Sulia Taluk. Stop. The learned AGA would therefore submit that Annexure B appears to be a bogus document. Stop. Next para. Having regard to the objections raised by the learned AGA, this court deems it fit to direct the second respondent, Tahsildar, Mudigere Taluk, to verify from the records as to whether such an application was indeed filed by the petitioner on 7/3/2019. Stop. If it is true that such an application was indeed filed and it was not considered till date, then the Tahsildar shall proceed to place the application along with its recommendation before the Committee for Regularization of Unauthorized Occupation within a period of 3 months from the date of receipt of a copy of this order. Stop. If it is found that such an application was not filed by the petitioner, then necessary endorsement may be issued by the Tahsildar to the petitioner stating that there is no such application pending consideration in his office. Full stop. Next para. If the application, on the other hand, is found and the Tahsildar puts it up before the committee, then the committee shall proceed to consider the application and pass orders as expeditiously as possible and at any rate within a period of 2 months from the date on which the application is placed before the committee. Stop. Ordered accordingly. Ali starting ali learned AGA takes notice admele at the oral request of the learned counsel for the petitioner, the description of respondent number 2 is permitted to be corrected as the Tahsildar, Mudigere Taluk, Chikmagaluru district. Learned counsel shall carry out the amendment forthwith. Please do it now. It's huh? ಏನಂತ ಹಾ ಅದೆಲ್ಲ ಬೇಕಾಗಿರೋದು. ಪ್ಲೀಸ್ ಶೋಸ್ ದಿ RTC annexure H. ಹಾ ಯಾರ ಹೆಸರಿದೆ? ಚಿಕ್ಕ ನಾರಾಯಣಪ್ಪ. ಹಾ ಹಾ ತಳಾರಿ ಮುನಿಗ ಅಲಿಯಾಸ್ ತಳಾರಿ ಚಿಕ್ಕ ಮುನಿಯಪ್ಪ. For him, a grant was made in his favor. ಹಾ ಹ್ಮ್ ಹ್ಮ್ ಮುನಿದಾಸಪ್ಪ has got a son Narsimappa and only son. ಹಾ ಹಾ ಇವಾಗ ಯಾರ ಹೆಸರಲ್ಲಿದೆ ಇದು? ದಿ ಫಸ್ಟ್ ಸನ್. ಹ್ಮ್ ಹ್ಮ್ ಚಿಕ್ಕನಾರಾಯಣಪ್ಪ is alive. ಹಾ ಹಾ ಹ್ಮ್ ಹಾ ಹ್ಮ್ 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 ಹಾ ಹ್ಮ್ ಮೇಲೆ ತಿಳಿಸಿದ ವಿಷಯದಂತೆ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ತಾಲೂಕು ನಂದಿ ಹೋಬಳಿ ಸೋಣಸು ನಂಬರ್ 11 ಪೈಕಿ ಸಂಬಂಧಿಸಿದಂತೆ ನನ್ನ ದೊಡ್ಡಪ್ಪ ಅಂತ ಹೇಳ್ತಾರಲ್ರಿ. ಹ ಯಾರಿಗ್ರಿ ಗ್ಯಾಂಟ್ ಆಗಿದ್ದು? ಚಿಕ್ಕದಾಸಪ್ಪ. ಹಾ ಹ್ಮ್ 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 ನನ್ನ ತಂದೆಯವರಾದ ಮುನಿದಾಸಪ್ಪ ರವರಿಗೆ ಚಿಕ್ಕಬಳ್ಳಾಪುರ. ನಿಮ್ ತಂದೆಯವ್ರಿಗೂ ಗ್ರಾಂಟ್ ಆಗಿತ್ತು? ಹ ನಿಮ್ ರೆಪ್ರೆಸೆಂಟೇಶನ್ ನೋಡ್ರಿ. ಕೆಳಗಡೆ ಲಾಸ್ಟ್ ಸೆಕೆಂಡ್ ಲೈನ್ 2 ಲೈನ್ ಇದೇ ಸರ್ವೆ ನಂಬರ್ ಪೈಕಿ ನನ್ನ ತಂದೆಯವರಾದ ಮುನಿದಾಸಪ್ಪ ರವರಿಗೆ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ತಾಲೂಕು ನಂದಿ ಹೋಬಳಿ 11 ಪೈಕಿ ಸಂಬಂಧಿಸಿದಂತೆ ದರಖಾಸ್ತು ನಂಬರ್ ಸೋನ್ಸೋ ನನ್ನ ತಂದೆ ಹೆಸರಿಗೆ 2 ಎಕರೆ ಮಂಜೂರಾಗಿದ್ದು There is no claim that it was granted to your father, grandfather. ನಿಮ್ಮ ರೆಪ್ರೆಸೆಂಟೇಶನ್ ತಪ್ಪಲ್ರಿ ಹಂಗಾದ್ರೆ. ನಿಮ್ಮ ರೆಪ್ರೆಸೆಂಟೇಶನ್ ರೀ. Why are you doing all this? If you bring some material before the court will look into all this material. And if the representation itself is like that, how can we give a direction? Why did your father and your uncle not get their names entered in the land records? You are saying if 2 acres were granted in favor of your father, then what to do now? ನಿಮ್ಮ ಅಂಕಲ್ದು ಆಗೋದಿಲ್ಲ because you will not be the first class legal heirs. This representation cannot be considered. Yes. Lord AGA, take notice for all the respondents. Although the learned counsel for the petitioner commenced his arguments for preliminary hearing, nevertheless, it is found that certain wrong statements have been made in the representation given by the petitioner while seeking mutation entry in his favor. So, therefore, learned counsel for the petitioner seeks leave of this court to withdraw the writ petition and file a fresh representation giving the correct facts. Stop. Next paragraph. Placing the submission of the learned counsel for petitioner on record, the writ petition stands dismissed as withdrawn, reserving liberty to the petitioner as prayed for. Huh? 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 ಆತ ಹಾಕಿದಾರ? ಪಾಸ್ ಓವರ್.
And the building company is due to for and proceedings are pending against the building company, and therefore the mutation cannot be done. LD is not exist. The sale agreement and the question is handed over. There is no impediment to mutate the khata in the name of the petition.
Where that agreement? You're not furnished a copy of the agreement? Ah. Annexure A, 2018.
This agreement is executed with one wind company. And that full consideration has been received. No, the sale deed has been executed. Possession is handed. We are not seeking any land back to petition, but she has seeking only invitation of her name in the car. Since the sale deed is not executed, title is still lying with the her deceased husband. Then they are handed over to possession. The registered agreement. Once the registered agreement, all of them will execute. Then seek for revenue.
Already, you should have implemented that agreement holder as a party respondent to the proceedings. We do not know what is his contention, its contention.
For the.
Huh?
The.
There it's okay. But here, if you are asking for a direction, then it's such a. Huh?
Since the title is
See,
not.
even otherwise, it will become necessary to enter your name, because without your name being entered, you will not be able to execute a sale deed in the favor of the company. Huh?
But then they have also to get muted my name in the revenue records. There is no impediment to enter my name in the company card. It is not possible to be. Failure execute ಮಾಡ್ಕೊಳ್ಬೇಕು ಮನೆ ಹೋಗ್ಬೇಕು.
There is an order passed by the attachment order has been passed. Howdri, property has been attached. No. There is a finding. You know, please. Have you furnished a copy of the order? This is not proper. in spite of knowing that such an order has been passed, referring to an order passed by the JMFC, you don't want to produce a copy of the order. What is the use then?
I will answer it clearly.
Learned AGA takes notice for all the respondents. Learned counsel for the petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Full stop. Next para. On going through the writ petition, this court finds that in the impugned order, there is a reference to an order of attachment said to have been passed by the learned JMFC, Bangalore. ಅದೇನು ಮಾರಾಟ ತೆರಿಗೆ ಅಂದ್ರೆ in criminal miscellaneous number 86 of 2020 stated 17/10/2020. Stop. Moreover, the petitioner herself admits that in terms of annexure A, a registered agreement of sale, the petitioner's husband has received the entire sale consideration at the hands of Messrs. Wind World, bracketly India, close infrastructure private limited. And the orders have been passed by the learned JMFC against the said company. Stop. That way of the matter, it becomes necessary for the petitioner to have impleaded the said company as a party responding to these proceedings. Stop. A copy of the orders passed on 17/10/2020 in criminal miscellaneous number 86 of 2020 is also required to be produced by the petitioner. Stop. Next para. Learned counsel for the petitioner seeks for a short accommodation to do the needful. We'll stop. 2 weeks time is granted to do the needful. Maybe. Two 2008 orders were passed in 2011. 2021 you filed writ petition directing the petitioners to file necessary appeal before the KAT. But they have stated that ordinance on the name of ordinance matter is not. Learned AGA, HCDP takes notice for both the respondents. So, the petitioner is aggrieved of the impugned order dated 17/11/2023 passed by the Karnataka Appellate Tribunal. In revision appeal number 140 of 2022. Stop. Next para. Earlier, the petitioner had approached this court in WP number 23631 of 2021. Challenging order dated 25/8/2011 passed by the first respondent Assistant Commissioner, Mandya Subdivision in LRF number 343 of 2011-12. Full stop. The Assistant Commissioner had invoked the provisions contained in Section 83 of the Karnataka Land Reforms Act for violation of and initiated proceedings for violation of sections 79A and B of the Act at the hands of the petitioner who had purchased the lands in question under a sale deed dated 24/3/2008. Stop. However, this court directed the petitioner to approach the Karnataka Appellate Tribunal and file necessary appeal in terms of the provisions of the Act. Stop. Consequently, the tribunal has passed the impugned order while rejecting the appeal on the ground that as on the date when the Karnataka Land Reforms bracketly Second Amendment Clause Act 2020 were brought into force, this matter was not pending consideration before any court or tribunal, and therefore the benefit of the saving clause in terms of subclause 2 of section 12 of the amending act will not inure to the petitioner. Stop. Next para. Learned counsel for the petitioner would draw the attention of this court to several orders passed by this court, including WP number ಅದಲ್ಲ ಇದು ನಮ್ಮ ಮಾಮೂಲಿ ಆದ 3271, including WP number 3271 of 2022 dated 17th of February 2022, whereby this court held that having regard to the provisions made in the amending act, more particularly subsection 1 and subsection 2 of section 12 of the amending act, if the excess lands after forfeiture were sold or granted to third parties, then it should be considered as the proceedings have attained finality. So, on the other hand, if the lands were not granted to any other party after forfeiture, then the provisions in subsection 2 of section 12 would be attracted. So, having held so, this court has remanded the matter back to the assistant commissioner to verify as to what is the position of the lands after forfeiture. Stop. Learned council press for similar orders. Full stop. Next paragraph. Consequently, paragraph number 7, same. To appear before the assistant commissioner on 13th of February. Yes. You know?
By considering the about 4 available. I found that taking an issue, they will be negating my bank on the ground that land is not available. And we are circular insights in the bank after the identity the government. So the order was possibly both every 2022. See my application is pending.
What do you want? You want a site? Annexure? Page number?
They are only content language to that.
Already, you didn't read the last sentence there. ರೀಸರ್ವೆ ನಂಬರ್ 25ರ ಪ್ರದೇಶವು ನಗರಸಭಾ ವ್ಯಾಪ್ತಿಯ ಗಡಿಯಿಂದ 2 ಕಿಲೋಮೀಟರ್ ಅಂತರದಲ್ಲಿರುತ್ತದೆ. ಇಟ್ ಇಸ್ Rule 10 of the land grant rules. Land grant rules. Land grant rules. Rule? Rule 10. Learned AGA, HCGP takes notice for all the respondents. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures in the learned HCGP. Full stop. Next paragraph. The contention of the petitioner that although in terms of the directions issued by this court, the WP number 9716 of 2021, dated 11/4/2022, and at the instance of the fourth respondent Tahsildar, Chikmagalur Taluk, a sketch is prepared by the Taluka surveyor at annexure L, stating that in survey number 25 of Kadri Midri village, Ambale Hobli, Chikmagalur district, 2 pieces of agricultural lands measuring 3 acre and 25 guntas and 30 guntas were available for grant, the Tahsildar has issued the impugned endorsement at annexure A, dated 5/10/2023, stating that there is no land available for grant. Stop. Next paragraph. Learned AGA, HCGP is directed to secure instructions having regard to the sketch prepared by the Taluka surveyor at annexure L. Stop. Release this matter on 30th of January. Huh? 79 AB na. Form number 7. What are you challenging here? Huh? You are a party to the proceedings? Huh? ಅಲ್ಲ ನೀವಿಲ್ದೇ ಇದ್ರೆ ಮಿಸ್ಟರ್ ಸಿದ್ದೇಗೌಡ. Huh? Then what is your contention? Huh. ಹಾಲಿ RTC ಎಂತೆ ಸರ್ವೆ ನಂಬರ್ 302ರಲ್ಲಿ ಶ್ರೀ ಸಿದ್ದಲಿಂಗೇಗೌಡ ಬಿನ್ ಪುಟ್ಟೇಗೌಡ ಮತ್ತು ಸಿದ್ದೇಗೌಡ ಬಿನ್ ಸಿದ್ದೇಗೌಡ ರವರುಗಳ ಹೆಸರುಗಳಲ್ಲಿ 4 ಎಕರೆ 10 ಗುಂಟೆ ಜಂಟಿ ಖಾತೆ ಇರುತ್ತದೆ. ಹಾ ಹಾ. So what has been granted under that order is not your land. ರೀ ಅದು ಬಿಟ್ಟು ಬೇರೆ ಎಕ್ಸ್ಟೆಂಟ್ ಆಫ್ ಲ್ಯಾಂಡ್ ಇದೆ ಕಣ್ರಿ. They have noticed the fact that 4 acres and 10 guntas is standing. Correct. If they have granted 1 acre, it cannot be part of your property. ಹೌದ್ರಿ, 4 acre 10 guntas ಅಲ್ಲಿ ಯಾವ್ದು ಕೊಟ್ಟಿಲ್ಲ ಕಣ್ರಿ. If they have to give it, then notice had to be issued to you. They have noticed the fact that 4 acres and 10 guntas belongs to Siddhalingegowda. Yes, no land, no part of that land has been granted here. Say, consequent to this order, revenue entries they had sought. Then how are you aggrieved? How do you know that? How are you saying that they are trying to get it? Is the notice issued to you? Then they have noticed the fact that 4 acres and 10 guntas are standing in the name of Sri Siddegowda. There cannot be a reason why, without even after noticing it, without even issuing notice to them, part of that land is granted to some other person. You are wrongly reading this.
The application submitted for survey number 300.
Correct.
The land is granted survey number 300.
Three not?
Land level only 4 acre 10 guntas. Entire land development. Is there. 58 savings. Last time. Otherwise, also survey grounds, something that was living control and investment. And it's a last time.
Huh? Huh? Application was filed for survey number 300. Huh? But in the last paragraph before the operative portion, they have noticed that ಅರ್ಜಿದಾರರು ಸದರಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 302ರಲ್ಲಿ 1 ಎಕರೆ ಪ್ರದೇಶದಲ್ಲಿ ಸುಮಾರು 25-30 ವರ್ಷಗಳಿಂದ ಅನುಭವದಲ್ಲಿ ಇರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಹಾಲಿ RTC ಅಂತೆ ಸರ್ವೆ ನಂಬರ್ 302ರಲ್ಲಿ ಶ್ರೀ ಸಿದ್ದಲಿಂಗೇಗೌಡ ಬಿನ್ ಹುಟ್ಟೇಗೌಡ ಮತ್ತು ಸೋನ್ಸೋ ಹೆಸರುಗಳಲ್ಲಿ 4 ಎಕರೆ 10 ಗುಂಟೆ ಜಮೀನು ಖಾತೆ ಆಗಿರುತ್ತದೆ. ಏನೋ ಮಿಸ್ಟೇಕ್ ಆಗಿದ್ದಾರೆ ಇದರಲ್ಲಿ. ಹೌದಾ, ನಿಮ್ದು ಅದೇನೋ ತಪ್ಪಿರ್ಬೇಕು. Learned HCGP takes notice for response number 1 and 2. Issue notice to response number 3 to 6. Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures on the learned HCGP. Full stop. Next para. Learned counsel for the petitioner submits that in the impugned order at annexure A, it was filed by Sri Molle Jogayya, he had sought for occupancy rights of 1 acre in survey number 300 of Avaramala village. Stop. The application was filed against Sri Dasharath Rao Mohante. Full stop. However, even after noticing the fact that the application was filed in respect of survey number 300, the assistant commissioner and the competent authority considering the application notices the fact that the applicant is said to have been in possession of 1 acre of land in survey number 302 and not survey number 300. And it was also noticed that survey number 302 belongs to Sri Siddhalingegowda, through whom the petitioners herein are claiming. Nevertheless, the assistant commissioner has proceeded to grant occupancy rights in respect of 1 acre in survey number 302, which is wholly impermissible and illegal. Stop. Learned counsel submits that in terms of the RTC produced at annexure C, the total extent of land ಜಾಸ್ತಿ ಇದೆಯಲ್ರಿ. ಇದ್ಯಾವ್ದು 299 ಯಾವ್ಯಾವ್ದು ಹಾಕಿದ್ದೀರಲ್ರಿ ನೀವು? ಏನ್ ಮಾಡ್ತೀರಪ್ಪ ನೀವು? Total extent of land in survey number 302 is 4 acre and 28 guntas, including 18 guntas of kharab. And therefore, when the assistant commissioner noticed the fact that Sri Siddhalingegowda is the owner of 4 acres in 10 guntas of land, even as per RTC, and since the claim was not against Sri Siddhalingegowda, there was no occasion for the assistant commissioner to have passed the impugned order granting 1 acre of land in favor of the applicant. Will stop. Consequently, there should be an ad interim order of stay of the impugned order till the next date of hearing. Please file necessary application Same order. Same order as. What number? Yes. All right. 37 also same order. Yes. Really, last ಅಲ್ಲಿ learned HCGT is permitted to file memo of appearance within a period of 4 weeks from today. Yes. Starting early to take notice. Huh? What is the matter about? At the request of learned counsel for petitioner, release this matter on 19th of January.
Without notice to the petitioner, revenue entries are changing. I don't find it under challenge the relationship before the second respondent. There was my referent before disputes that I was the son of children. And there is also a suit pending with respect to this fellow. There is my revision petition is rejected on the ground that I have to back out the in the civil case. I have challenged the said order to the first respondent. The order assessment petition is updated. The declaration is finally something as
all right. Let there be a status quo in respect of the revenue entry. As and when you succeed, get a declaration, you will be entitled to have your name entered.
Now my lord's responding on the file, he has filed a petition before to change the entries in his name. Now it is acting in the joint use of mother and his son. Now he has filed one more petition to change the entries in his name.
There file objection.
I have filed.
Yes, if they consider. For that one, you will not get a cause of action here. If any adverse order are passed on that application, then you will get a cause of action. You make the same submission during the pendency of the suit, they can't come and ask for change in the revenue entries. Let it remain as it is till the suit is disposed of. You file that objection. ಇವಾಗ ಏನಾಗಿದೆ? ಸ್ಟೇಟಸ್ ಕೋ ಕೊಡಲ್ಲ ಅಂತ ಯಾರಮ್ಮ ಹೇಳ್ತಾರೆ?
Rightly or wrongly, I have the right to observe. Without notice to me, the entries are changed to the second right.
Which is the impugned order?
Orders passed here.
What is the deputy commissioner held?
He has after the order.
What is the order of the assistant commissioner? Hmm. Ah. Huh? Ah, correct. Ah, you approach the assistant commissioner, is it? Then ನೀವು ಅಲ್ಲಿ ಸೂಟು ಹಾಕ್ತೀರಾ, ಇಲ್ಲಿ ಬಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಇಲ್ಲ ರೆವಿನ್ಯೂ ಎಂಟ್ರೀಸ್ ನನ್ನ ಹೆಸರಿಗೆ ಮಾಡಿ ಅಂತೀರಾ? Correct. Why did you approach the assistant commissioner? Which mutation entry? MR number 64 of 98-99 you wanted to challenge in the year 2010-11. Then what will happen? What you are now seeking is, though you filed a suit in the year 2014, you want the revenue entries now to be changed, which was done in the year 1998. How is it permissible? Not possible. You only have to file an application and get a direction that the property should not be alienated during the pendency of the suit. The revenue entries, even if it is changed, it doesn't matter at all. Yes, madam, that entry was made in the year 98. So therefore, why should there be a change when you have approached the civil court seeking a declaration? Let the declaration come, then thereafter there can be any change. At your instance, the mutation entry that was changed in the year 1998 cannot be changed now. So there is nothing wrong in the impugned orders. Purple. ಈಗ ಇನ್ನೊಂದೇನಾರು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ಅವ್ರಿಗೆ ಅವರು ಯು ಗೋ ಫೈಲ್ ಅಬ್ಜೆಕ್ಷನ್. Our earlier petitions were not entertained only on the ground that a suit is pending consideration. Now how can you entertain another application? ಹೇಳಿ ನೋಡಿ. Yes. Learned AGA takes notice for response number 1 to 3. Notice to response number 4 and 5 is not necessary for the following reasons. Stop. Having gone through the petition papers, this court finds that the dispute between the petitioner and response number 4 and 5 is touching upon the title of the land in question. So the petitioner has already filed OS number 526 of 2014. Before the civil judge in JMXC, Mandya, seeking a declaration that the name of the plaintiff's father is Sri Shivlingayya. Stop. The claim is in respect of the very same property and its revenue entries. So during the pendency of the suit, the petitioner even before the filing of the suit, the petitioner had approached the assistant commissioner challenging a mutation order in MR number 64 of 1998-99. So the assistant commissioner dismissed the appeal. On the ground that there is no material available to show that the petitioner is the son of Sri Shivlingayya. And at any rate, the said question cannot be decided by the assistant commissioner. And the petitioner had to approach the competent civil court to get a declaration. Stop. The revision petition filed by the petitioner before the deputy commissioner was also dismissed by upholding the order of the assistant commissioner. So the deputy commissioner has also noticed the fact that subsequently the petitioner has filed a suit seeking a declaration, and therefore the petitioner had to await the decision of the civil court. Full stop. Next para. This court does not find any infirmity in the impugned orders. Full stop. However, if in the interregnum the contesting respondents seek further change in the mutation entry, the petitioner may raise objections that pending consideration of the suit, such intermeddling with the mutation entry will be to the prejudice of the petitioner, and therefore such application should not be entertained. Full stop. Next para. With these observations, the writ petition stands dismissed. Of course, there is no need for this court to say that at all. If there is a declaration in your favor, you are entitled to have the name entered.
Land. And wait in Apani. And then the revenue entries continued into them after 94-95. In the year 94-95, all of a sudden, without any prior information, so on. This is the standing in mind in the revenue. Bracket and the names of the respondents are really fact was unavailable. After knowing of this fact, we paid the appeal before the assistant. The assistant said this and restored the existing document. In a statement, we paid the appeal before the deputy commissioner. During the COVID period, then grow notices served, but we are not in a position for doing this. Export order we made without giving us an opportunity. That way, we had no opportunity was given. From that reason, we were switching the record of this matter to the people. Page 99 is
AGA takes notice for response number 1 to 4. Issue notice to response number 5 and 6.
So, the land.
Anyway, see, if there are contesting respondents, without issuing notice, we cannot set aside the order. We will see. Learned counsel for the petitioner petitioners is directed to serve a copy of the writ petition along with annexures on the learned AG. Sorry. For what? You want the matter to be remanded. Why do you want records? We will not go into all those aspects. You are saying it's an ex parte order. You want the matter to be remanded? Yes. Yes.
The appeal and acted with the committee to consider my application and to collect the funds, find out that the land survey in which I am present and I am the owner of survey number 195. Isn't it that correct to think because of land? Definitely I have raised monthly photographs also I have produced one. Now that as this is the case is pending before the regularization committee as per the directions of assistant commissioner. The deputy commissioner has passed an order granting this land for reserving this land for buyback. Already there are 2 burial grounds. I have produced photographs of the said burial ground also. And then this observation is that no such application is found, no applications are pending.
Where is the order of the assistant commissioner? Button.
Order. Easy. Page 28. Addition.
So the order also. Elli they buried the order operative portion of annexure F. ಶಿಡ್ಲಘಟ್ಟ ತಾಲೂಕು ಜಂಗಮಕೋಟೆ ಹೋಬಳಿ ಕೆಜಿಪುರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 29ರಲ್ಲಿ 23 ಗುಂಟೆ ಜಮೀನು ಕೆಜಿಪುರ ಗ್ರಾಮದ ಗ್ರಾಮಸ್ಥರಿಗೆ ಸಾರ್ವಜನಿಕ ಸ್ಮಶಾನಕ್ಕಾಗಿ ಮಂಜೂರು ಮಾಡಲು ತಯಾರಿಸಿರುವ ನಕ್ಷೆ.
ಸರ್ವೆ ನಂಬರ್ 29
Yes.
That reason only the assistant commissioner is ordered to directed the authorities to inspect the spot and find out the survey number in which period is unauthorized cultivating. Takes 27 years to find it. Higher number
32 ಬಾರ್
and one number. And one number. So participated survey number. ಅದೇ ನಾವು ಕನ್ಫ್ಯೂಸ್ ಮಾಡಿ 30/5 ಹಳೆ ನಂಬರ್ ಆಪರೇಟಿಂಗ್ ಫಂಕ್ಷನ್ ಹೇಳಿದ್ದಾರೆ ಸಾಹೇಬ್ ಅಪ್ಲಿಕೇಶನ್ ಅದು ನನ್ನ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ ನ ಸರಿಯಾಗಿ ಫೈಂಡ್ ಔಟ್ ಮಾಡಿ ಸ್ಪಾಟ್ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಕಂಡಕ್ಟ್ ಮಾಡಿ ಆಮೇಲೆ ಇದಕ್ಕೆ ಇದು ಸರಿ ಓದ್ ಮೇ 30 ನಂದೆ 29 in the land they have not asked for 29 ಅದನ್ನೇ ನಾವು ಕೇಳಿ ಬೋರ್ಡ್ ಸರ್ವೆ ನಂಬರ್ 1 ಅಂತ ಹೇಳಿ let them find out already. Find out in portion of this minute they are at liberty to take up. Other copy is there in existence. Today also it is there. Litigation ಮಾಡಿ ಎಲ್ಲ ಬರ್ತಿದೆ.
Learned AGA. Take notice for response number 1 to 5. ಅಲ್ಲಿ ಇದು ನಂಬರಿಂಗ್ ಅಲ್ಲಿ ಮಿಸ್ಟೇಕ್ ಮಾಡಿದಿರಾ ನೋಡಿ. Issue notice to respond number 6. When it comes for petitioner, he is directed to serve a copy of the petition along with the annexures on the learned AGA. Full stop. Next para. It is the contention of the petitioner that although there is an order passed by the Assistant Commissioner on 22/12/2021 proceedings were initiated under 108K na for what? Cancellation of what? Huh?
They have challenge. They have both the AC and petitioner challenge. They have filed under
Who?
petitioner. PAC.
Huh?
What is the offering?
Huh?
File ಮಾಡಿ.
ಏನಂತ? ಏನಂತ? What did you? Why did you approach the Assistant?
was not considered.
Huh?
My application was filed.
Huh?
My application was not considered and it was kept in abeyance.
Huh?
For that reason, this appeal was filed with me to pass an appropriate direction to consider my application.
In respect of survey number 30/5 ಹಳೆ ನಂಬರ್ ಅಲ್ಲೇ ರೆಗ್ಯುಲರ್ ನಂಬರ್ 1ರಲ್ಲಿ 1 ಎಕರೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಸರ್ವೆ ನಂಬರ್ 1 ಮಾತ್ರನೇ ನಾವು ಹಾಕಿ ಹಳೆ ನಂಬರ್ ಅಂತ ಹೇಳಿ ಹಾಕಿದ್ವಿ.
ಆರ್ಡರ್ only in respect of survey number 30/5. The land now is reserved is survey number 29.
This is a directive or issued to consider application filed in Form 53. Only for survey number 1 only. What survey number 1? 53 is my land and Idwadi land.
ಹೊಸ ಸರ್ವೆ ನಂಬರ್ 1 ಅಂತೀರಾ?
That ಅವ್ರು ತಪ್ಪಾಗಿ ಹತ್ರ ಅರ್ಥೈಸಿ ನಾವು ಫೈಲ್ ಮಾಡಿದ್ರೆ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಇದೆ
And the survey number is dated and
Exactly.
But in paragraph number 2 of the petition, they have clarified. ಆಯ್ತು, ವೆರಿಫೈ ಮಾಡಿ. But if your application is not very clear, then ಏನು ಹೇಳಿದಮ್ಮ? ಹೇಳಿ ಏನು?
Petition that although there is an order passed by the Assistant Commissioner on 22/12/21
Directing the Committee for Regularization of Unauthorized Occupation to reconsider the application filed by the petitioner in form number 53 seeking regularization of unauthorized occupation of 1 acre of land in new survey number 1 and old survey number 30/5 of KG Pura village, Jangamakote Hobli, Shiddughatta Taluk, the Deputy Commissioner, by virtue of the impugned order at Annexure F dated 3/12/2022 has proceeded to reserve 23 guntas of land for which regularization is sought by the petitioner, for the purposes of burial ground. Stop. Learned counsel submits that unless the application of the petitioner is considered and disposed of, there is no occasion for the deputy commissioner to consider grant of the said land or any portion thereof for any other purposes. Stop. Next para. For contra, learned AGA points out from the impugned order, official memorandum, that what is granted is 23 guntas in survey number 29 and not survey number 30/5, for which application has been filed by the petitioner. Full stop. Next para. Learned counsel for the petitioner, however, draws the attention of this court to paragraph number 2 of the writ petition, wherein it has been clarified that the petitioner is the owner of 1 acre and 24 guntas in survey number 30/5, and the land in question is survey number 29, which is adjacent to his lands, and the petitioner has sought for grant of 1 acre land in survey number 29, which has wrongly been stated in the orders passed by the assistant commissioners. Full stop. Next para. In that view of the matter, there shall be a direction to the respondent authorities, including the deputy commissioner, that no further action shall be taken consequent to the impugned official memorandum at Annexure F till the next date of hearing. Full stop. The learned AGA is directed to secure instructions from the fourth respondent, Tahsildar, Shiddlughatta Taluk, as to the details of the application filed by the petitioner, which is pending consideration before the said authority, and which was required to be reconsidered by the committee. Stop. Release this matter on 30th of January. Huh?
See what I try to order.
7980. Where is the order of the assistant commissioner? Annexure E na? Huh? This application is filed or you want to file it now? Learned AGA takes notice for both the respondents. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Full stop. Next para. Learned counsel for the petitioner submits that the petitioner intends to file an application seeking amendment in the prayer to raise a challenge to the impugned orders passed by the Assistant Commissioner at Annexure C. Full stop. The application may be filed in the office. Yes. Yes. That is the only office objection, is it? Huh? You should have put up a note. You put up a note. As regards office objection, that respondent number 7 in the proceedings before the Deputy Commissioner at Annexure A has not been made a party to the proceedings, to this writ proceedings, learned counsel submits that a note has been put up below the cause title stating that respondent number 7 has passed away and therefore he is not made a party to these proceedings. We'll stop. But how about his legal representatives? Even otherwise, it is submitted that respondents number 5 to 7 are the legal representatives of respondent number of Shri Mahadeve Gowda. Stop. Next para. The submission of the learned counsel for petitioner is accepted. Office objection is overruled. Yes.
The RTC entries, which are not added in the name of the petitioner, have been sought to be replaced.
Who approached the Assistant Commissioner?
Originally, this property came to be granted in favor of my grandfather, in the year 1952. Subsequent to which since 1970, the name of one Siddhaya started transferring even before the mutation entries with the RTC. Therefore, I challenged the same on 2006 before the Kakila, who refused to interfere because of time lapse. Subsequently, in the last 2007, I challenged the same before the Assistant Commissioner to interfere And after the fact they are looking to the place once again, and also may not start an order, they have been staying the necessary direction to remove the entries made in the RTC.
Where is that order?
Because way back in the year 2007, subsequently the draft. ಇದೆ ಮೇಲ್ಮನವಿ ಅಂಗೀಕರಿಸಿದೆ ಮೈಸೂರು ತಾಲೂಕು ಮಾದನಹಳ್ಳಿ ಗ್ರಾಮ ನಂಬರ್ 19 ಗುಂಟೆ ಜಮೀನಿಗೆ ಪ್ರಾಣಿಯಲ್ಲಿ ಮುಂದಾಗಿರುವ ಸಿದ್ದಯ್ಯ ಕೆಂಪೇಗೌಡ ಹೆಸರನ್ನು ರದ್ದುಪಡಿಸಿದೆ. Is what had been given. Then later, my lords, these private respondents had approached the Honorable Civil Court in a suit for declaration, my lords, which is the page number 42, connection E. This suit, my lords, came to be dismissed for non-prosecution. The advocate annexure 3, my lords, relevant order operating position is at page number 56, my lords. Very good. And even super declaration, they did not persuade further, they are repeated at that stage, my lords. The dismissal was in the year 2010. Subsequently, my lords, the entries what were made in the RTC was not rectified at all. Therefore, my lords, on 2017, after approaching the Assistant Commissioner, once again an order came to be passed, which is at page number 57, my lords. Thereby, removal of entries illegally made in favor of Siddhayam. Later, my lords.
You once again approached the Assistant Commissioner.
Yes, and
Why?
no effectuation of the order was made and there was a time lapse. After 2007, since till in the year 2017, no effect was given to Lux. Therefore, I had to approach the Assistant Commissioner once again. Interestingly, Lux, in the very same case, the deceased Mr. Nahadevegowda he himself makes a statement at paragraph number 3 of page number 58. There it is said that ದಿನಾಂಕ 15/3/2017 ಎರಡನೇ ಎದುರುದಾರರಾದ ಮಹಾದೇವೇಗೌಡ ಲೇಟ್ ಸಿದ್ದಯ್ಯ ಅವರ ವಕೀಲ ಮುಖಾಂತರ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರಾಗಿ ಬೈದರಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 19ರಲ್ಲಿ 1 ಎಕರೆ 31 ಗುಂಟೆ ಜಮೀನು ಸಾಧನಾದ ಡೇಟ್ 1952ರಂದು ಸರ್ಕಾರದಿಂದ ಸಾಗುವಳಿ ಮುಖಾಂತರ ಬಂದಿರುವಂತಹ ಸ್ವತ್ತ ಇರುತ್ತದೆ. ಹಾಗೂ ಈ ಸರ್ವೆ ನಂಬರ್ನಲ್ಲಿ ಮಾಲೀಕರು ನಿರ್ವಹಿಸಿದ್ದಾರೆ ನಮ್ಮಗಳ ಯಾವುದೇ ರೀತಿಯಾದ ಹಕ್ಕಿಲ್ಲ, ಹಿತಾಸಕ್ತಿಗಳ ಮಾಲೀಕತ್ವವಾಗಲಿ ಸ್ವಾಧೀನಾನುಭವ ಇರುವುದಿಲ್ಲ ಎಂದು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ಮೇಲ್ಮನವಿದಾರರ ಹೆಸರಿಗೆ ಸದರಿ ಸರ್ವೆ ನಂಬರಿನ ಜಮೀನಿನ ಖಾತೆ ಮಾಡಲು ನಮಗೆ ಆಕ್ಷೇಪಣೆ ಇರುವುದಿಲ್ಲವೆಂದು ಲೇಟ್ ಸಿದ್ದಯ್ಯರವರ ಮೊದಲನೇ ಮಗನಾದ ಮಹಾದೇವೇಗೌಡರವರು ನ್ಯಾಯಾಲಯಕ್ಕೆ ತಿಳಿಸಿರುತ್ತಾರೆ. Subsequently, my lords, there was this appeal can be allowed. Later, my lords, the revision was preferred before the Deputy Commissioner of the Lords. Deputy Commissioner jurisdiction has a limited jurisdiction as in accordance with law. Even at paragraph number 4 at page number 18, for even he quotes a reason saying that on 25/10/1928, the sale deed amount to anyone, till date not produced anywhere. He says that by virtue of this sale deed, Siddhaya has got the property. And therefore, he says that the RTC entries, whatever has been paid, has to be reversed, and Siddhaya's name has to stay also. Over this, whatever is supposed to be done in revision, point 1.
But if there is a certified copy of the sale deed,
Yes.
then it takes a different color.
It's not document at all today.
How do you know?
Because it has not been produced. Because even in civil suit, my lords, I draw the attention on the statements that they are made in the civil suit. And one more important document is that, my lords, I draw the attention of this honorable court to document number.
All right.
Section 3, my lords, page number 36, page number 37 is the relevant question.
Yes, Barkul. Learned AGA takes notice for response number 1 to 4. Issue notice response number 5 to 7. Learned counsel for the petitioners is directed to serve a copy of the petition along with the annexures and the learned AGA. Stop. Next para. Learned counsel for the petitioners submits that in an appeal filed by the petitioners before the Assistant Commissioner invoking section 136(2) of the Karnataka Land Revenue Act, on the basis of an affidavit filed by ಇಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ ಶ್ರೀ ಮಹಾದೇವೇಗೌಡ son of Siddhaya, that 1 acre and 30 acres of land in survey number 19 of Maidanahalli village was granted in favor of Sri Bettegowda, the grandfather of the petitioner Sharon, on 22/6/1952, and therefore the revenue entries can be continued in the name of the petitioner Sharon. The assistant commissioner proceeded to allow the appeal by order dated 3/5/2017, directing the removal of the name of Sri Siddhaya, son of Kempegoda, in the land records in respect of survey number 19 measuring 1 acre 31 guntas, and to continue the name of the petitioners in the land records. Stop. However, the deputy commissioner has for the first time made an observation that the land in question was purchased by Sri Siddhegowda, son of Kempegoda, under a registered sale deed dated 15/10/1928. Page 19 ಅಲ್ಲಿ 15/10/1928 ಅಂತ ಇರೋದು. Which one is correct? 15/10/1928, which was never the case of the contesting respondents, even in the suit filed by them in OS number 2006. REL ಹಾಕಿದ್ರಲ್ರಿ, ರೆಗ್ಯುಲರ್ ಅಪಿ ಇಲ್ಲ. Next para. Consequently, there shall be an ad interim order of stay of the impugned order dated 2/1/2024 at annexure A, till the next date of hearing. Finally, 2 weeks time. Finally, a week's time is granted for complaints of office objections. So, release this matter on 25th of January 2024. Stop. If office objections are not complied, the writ petition will be dismissed.
Number 18 मिला दो.
Huh? Annexures to be stated for OS number that objection, you know? Huh? What is this OS and petition number 10943?
Endorsement issued annexure A, similar endorsements issued. The deputy commissioner has issued the circular to the all the tahsildars not to enter the interim orders granted by the civil courts if they are the revenue authorities are not parties in the proceedings. The orders by the appellate authority and civil courts do not be. Then they will be sent the next pass.
Where is that order?
That order, based on that order, that the endorsement was issued. Annexure G.
Sir, if you are referring to an order, they are saying where is that order? Where it is not produced as an annexure. Huh?
ವಿಷಯ ಹಾನಿ ಕಾನೂನುಗಳ ಅನ್ನದಂತೆ ಮಾನ್ಯ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದ ಮಧ್ಯಂತರ ತಡೆಯಾಜ್ಞೆ ಆದೇಶವನ್ನು ಇಲ್ಲಿಗೊಳಿಸಿತು. ಜಿಲ್ಲಾ ಸರ್ಕಾರಿ ವಕೀಲರು
Already, you have mentioned something about judgment in OS number 1341 of 2021 and WP number 10943 of 2020.
annexure F that judgment.
Huh?
The judgment annexure F page number 25. The coordinate bench on the same point that the issued direction to that they all the endorsements issued based on sector that was quashed. And issued direction.
What is this OS number 1341?
The petitioner has filed this suit and got the interim.
Where is that?
The annexure C that page number 13. The interim. Not alienated. Petitioner made request to Tahsildar. Tahsildar has issued an endorsement annexure A.
Office objections are overruled. Really?
That petitioner has filed this suit with regard to interim order. Made request to the Tahsildar to enter the interim order column number 9 and column number 11.
Under which provision?
That project 127, 1B, library.
Huh?
127.
Ah.
1B. Record of rights. Record of rights shall be prepared in the prescribed manner of every village. Such records shall include the following particulars. Names, persons who are the more occupants, voters, mortgage, landlords, tenants of the land, assigns, rent, and revenue thereof. Nature and extent of the specific interest of such persons and the conditions or liabilities if any attaching date. This project was referred to coordinate liabilities. That the operating provision of that the party one. Paragraph, page number 43, paragraph 8. Okay. In the legal parlance, ordinary liability means legal responsibility for one's act or omission or any other words. Means aggregation to be responsible or answerable in law. And when this expression is read in conjunction with the requirement section 127(1)(b) of the Act, which states that the record of right shall include the nature and the extent of the respective interest of such person and the conditions, liabilities, if any, attaching to the land. There cannot be any doubt that details of the interim marks of the courts are to be entered in the articles. Further, there is no nexus for limiting the entries in column 11 of the articles on his proceedings, where the revenue authorities are not parties, and excluding the other civil proceedings and the existence cannot provide over the purpose of statutory purpose. Therefore, implement circular cannot be sustained unless it is ready. The direction to be concerned revenue authorities to include the details of the remarks granted by the civil courts in the original or appeal proceedings. As such, circular 25/11/19, including the direction to maintain
mention the details of the process granted by the civil code. Even in the civil, even in the proceedings to which the revenue authorities are not parties, provided the authorities are satisfied. In which, even in case that the arms pertaining to subject properties and involves any person doing the instant as a author who has to depend on the answer by their this one the circular issue by the deputy commissioner, this endorsement issue by the other tahsildars. All these the matters are from that the endorsement issue based on the circular issue by the deputy commissioner. The circular, the endorsements are passed. Even of the others.
What is the interim order that you are talking of?
Not to eliminate the problem. The operating person page number 13 had an interim order export PI or is granted in a dependent agent releasing hereby restraint from creating third party rights for the suit DLC property in the next state of it.
ರೀ ಹಿಂಗೆಲ್ಲ ಮಾಡಿದ್ರೆ ಏನಾಗುತ್ತೆ? Every time there is a change in the order, every time you will have to go and mention it and get it changed. ಹಿಂಗೆಲ್ಲ ಮಾಡಿದ್ರೆ ಹೆಂಗೆ?
Multiple litigations by the respondents or the defendants. If there is an interest is involved, there is a suit is filed, the suit is same surveillance. All is there. If the revenue authority is not parties, we are not responsible to enter the charge.
ಅದಲ್ರಿ ಅದನ್ನ ಬಿಡ್ರಿ, you leave forget about other those aspects. See, if there is a judgment passed by the competent court, civil court, a decree has been passed. Whether that is reflected in the RTC or not, will not make any difference. If a person acts contrary to the decree, then the law is there to take care of such a situation. Why every time it has to be entered in the in column number 11? How many times you are going to make those changes in the RTC then? The ex parte order you are pointing out. So what? The other side doesn't know that this kind of an order has been passed. Then why do you want the entry in the RTC then? For what purpose, sir?
The apprehension is the defendant.
Sir, there is a order passed against the defendant. He knows fully well that there is an order restraining him not to alienate the suit schedule property. Then, sir, please understand. The party has appeared before the court. He knows very well that this kind of an order is passed by the court. How will he alienate the property? And what are the consequences of alienation? ಮತ್ತೆ ಏನಕ್ಕೆ ಬೇಕು ಅಂತ? Every time this kind of an order is passed. Now if it goes before the appellate court, get it set aside, again it has to be reported and removed. Then again if you come to the high court, get that order set aside, again it has to be put in. ಹಿಂಗ್ ಮಾಡ್ಕೊಂಡು ಹೋದ್ರೆ how many entries will have to be made? ಅದೇ ರೀ, it goes on changing as and when orders are passed by the court.
In order to protect the property,
Sir, you have an order of the civil court which is protecting you.
revenue authority is responsible to enter the
See, the plain reading doesn't make it so clear. You are now depending on an order passed by this court. Isn't it?
Yes.
A plain reading of that provision will not indicate that every time an order has been passed by, interim orders have been passed by a court, interim order or final order. It has to be entered in the column number 11. It doesn't make it clear. It is not express. It is an interpretation of this court. And the other party who would be affected is not made a party here. You don't want the matters to be contested. Huh? You want an order behind their back. ಹೌದ್ರಿ ನೀವು ಹೆಂಗೆ ಬಾರಿ ಸಿಂಪಲ್ ಆಗಿ ಆಸ್ ಇಫ್ ನೋ ಪ್ರೆಜುಡಿಸ್ ವಿಲ್ ಬಿ ಕಾಸ್ಟ್ ಟು ದಿ ಅದರ್ ಸೈಡ್ ಒಂದು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಬಿಡಿ ಸ್ವಾಮಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಾ. ಇಟ್ಸ್ ಅನ್ ಎಕ್ಸ್ ಪಾರ್ಟಿ ಆರ್ಡರ್ ಸರ್. You may say they could have got it set aside in a manner known to law. Similarly, if you want such a direction, is it not the natural principles of justice, principles of natural justice, that a person who would be affected should be a party respondent to the proceedings? And without notice, can we issue such a direction? Learned AGA takes notice for all the respondents. Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA. We'll stop. Next para. To a pointed question as to why the person against whom the interim orders are passed by the civil court, which the petitioner seeks to be entered in column number 11 of the RTC, is not made a party respondent to these proceedings. Learned counsel for the petitioner seeks for a short accommodation to file necessary application to implead the said persons as party respondents to the proceedings. A week's time is granted to do the needful.
Devendappa. 17.
Finally, 2 weeks time is granted for complaints of office objections.
Number 18.
I represent the petitioner, Milad. Court fee first, court fee I have paid on 31 and 30th 5/23. First objection I have complained, Milad. Court fee I have paid, Milad. So underline removal, I have filed typed copies. In place of the copies which were underlined, I have filed the typed copies. Annexures 3 has also been complained, Milad. I have mentioned all the dates. And the age of the petitioner alone is to be corrected, Milad. Rest of the office objections I have complained, Milad. Age of the petitioner is 78 instead of 76. Except that all other objections have been complained, Milad. And 6th does not arise, Milad. This is the 4th writ petition that has been filed by the petitioner, Milad. And in earlier 3 writ petitions, this honorable court has not insisted for the certificate of registration of the petitioner. And I have produced all the 3 orders passed by this honorable court prior to this writ petition, wherein, Milad, the petitioner was granted 2 acres 7 guntas of land in 1965. Out of that, 1 acre was given to him in possession.
Office objections are overruled. Yes.
Milad, the petitioner got 2.7 acres of land. He has made an application seeking grant from the first respondent, Milad. Out of that, and he has also made a payment on 24/2/1965 to the first petitioner, to the first respondent. and 1 acre of land has been granted. That has been challenged by him. Subsequently, my lord, the application has been filed seeking a grant of that entire 2 acres 7 guntas of land to him, to them. That has not been considered. The first writ petition came to be filed. Then, my lord, the respondents have contended that the land which is pending to be granted was allotted to the second respondent social welfare department. And my lord, I have produced material before the deputy commissioner Mandya that they have already been granted land for their purpose. And thereafter, my lord, the report has also been stated by the
Learned HCDP takes notice for all the respondents. Learned counsel for the petitioner is directed to serve a copy of the decision along with annexures on the learned HCDP. Full stop. Next para. 3 weeks are granted to the respondents to file statement of objections. Please file statement of objections.
Much, Lord.
Huh? Where is the memo? ನೀವೇ ಇಟ್ಕೊಂಡು ಹೇಳ್ತಿರಲ್ರಿ. Who has signed this memo? Who has signed this memo? Huh? Your senior or you? Your senior as well. Huh? Who has filed this, signed this memo? Your senior. Huh? Okay. ಅದೇ ರೀ ಅವರೇ ಸೈನ್ ಮಾಡಿರೋದ ಇದು ಮೆಮೋ ಅಂತ ಕೇಳ್ತಾ ಇದೀನಿ. ಹಾ ಇಲ್ಲಿ ವಕಾಲತ್ತಲ್ಲ ಸಿಗ್ನೇಚರ್ ಬೇರೆ ತರ ಇದೆ, ಇಲ್ಲೇ ಬೇರೆ ತರ ಇದೆ. Then counsel for the petitioners has filed a memo dated 17/1/2024 stating that the writ petition has become infructuous as the respondent has cancelled the grant order the cancellation order has been questioned, has been challenged by the petitioner by filing another writ petition in WP number 24663 of 2022. So, that way of the matter, it is prayed that the petitioner may be permitted to withdraw the writ petition. Full stop. Next para. The memo is taken on record subject to all just exceptions. Full stop. Accordingly, the writ petition stands dismissed as withdrawn. Huh? ಏನ್ರಿ ಹಂಗಂದ್ರ ಅರ್ಥ ಏನ್ರಿ? ಮತ್ತೆ ಇನ್ಯಾರು ಯಾರ ಮೇಲೆ ಕೇಳಿದೀರಾ? ಹಾ? See, those persons filed a regular appeal before the Assistant Commissioner against you. Huh? The impugned order has been passed in their favor. Huh?
Land is totally in the-
As per section 1, the grant condition is violated. So, land bearing survey number 29/2 measuring 3 acres 18 guttas are hereby forfeited to government. The appellants have violated the rule and conditions imposed. How are you saying they will not be affected? At their instance, the grant made in your favor has been cancelled. Then,
Yes, they sold the property in my favor.
you know,
Same ಮಾಡಿದ್ದಾರೆ. 2004.
who are the persons who approached the Assistant Commissioner?
As the legal heads of Procedural branches, they sold the property in my favor in the year 2004. Section 61 violation of the grant condition violation of the.
And how are you saying that they will not be affected? Are you not challenging the order of the Assistant Commissioner here? And at whose instance the order was passed? At their instance. Then it's natural that they are to be appraised of that you have raised a challenge to the order of the Assistant Commissioner. How can we say they will not be affected? Since they were affected, they approached the Assistant Commissioner. What is this?
Under section 61.
No, sir. Office objections have to be complied. 2 weeks time is granted at the request of learned counsel for petitioner for compliance of office objections. That is to show the other parties to the proceedings at Annexure A as party respondents to these proceedings.
22, first time non-compliance. Hajaram,
Huh? Finally, a week's time is granted at the request of learned counsel for petitioner for compliance of office objections. Release this matter on 24th of January 2024. If office objections are not complied, the writ petition will be dismissed.
Shakarya.
Just the same order.
Yeah, Malla.
Same order. It will be relisted on 24th. Huh? 25th.
Order. 26, Dilip Kumar. PF, second time.
You know? Why are you not taking steps? See, that order was passed on 26th of October. Huh? Finally, a week's time is granted at the request of learned counsel for petitioner for taking steps for service of notice on the proposed respondents in terms of order dated 26/10/2023. Stop. Ekara. In the meanwhile, if any application has to be filed for bringing on record the legal representatives of deceased petitioner number 1, comma, the same shall be done. Yes. Huh? Non-compliance of officer objection for 7th time. Huh? ಇನ್ನು ಎಷ್ಟು ಟೈಮ್ ಕೊಡಕ್ ಬರುತ್ತೆ ನಾವು? ಏನಾಗಿದೆ ಇವಾಗ? ಹಾ ಹಾ this is the 7th time that the matter is coming up for this. That order was passed in August 2022. Okay. On 22/8/2022, this court had recorded the submission of the learned counsel for petitioner that the sole petitioner is no more and necessary application is required to be filed to bring the legal representatives on record. Stop. Till date, no such application is filed and office objections have not been complied. Stop. Next para. By effects of time, the petition has abated and consequently the writ petition stands dismissed as abated. Yes. Same, huh? Huh? I think the same, huh? Same. Same orders. 3/9/2022. Huh? The order was passed. Same. Terms of order dated 12/7/2023.
State by the.
Huh.
Then this one, slab of PPP, we did subsequently.
Huh.
By objective 27/9/2023.
Yes.
Yeah, I know. It's one of the five.
Your objections are ready. Huh? No, file it in the office. Learned counsel. Correspondent number 5 submits that the statement of objections are ready. Stop. The same shall be filed in the office while serving a copy on the learned counsel for petitioner as well as the learned AGA. Yes. Interim orders granted earlier stands suspended till next date. Huh?
Both the.
Yes.
There is a note in the process. So, they are served and they are represented. Which may be. What is the effect of completing happening on
The office note which is put up in WP number 9521 of 2021 shall not be put henceforth. Yes. Huh? This matter for final disposal on 31st of January. Yes. You know? Yesterday, what Mr. Ashok Karnali had argued. Was quote same. So same orders. As in WP number 20062 of 2021. Nenne order ಮಾಡಿದ್ದೀವಿ. Learned HCDP submits that he has received copies of the petition. Yes.
hearing challenge the RTC in case of standing. Instead of like that, this is the management together the land. Yeah. The says the occupancy rights have been granted by the deputy commissioner finance in your paper. Plus, I admit the Lord's the grant of occupancy rights made by the deputy commissioner. Other condition is that the survey numbers are listed, but they have been granted with survey number 8/3, which is renamed as survey number 20 after the survey. Whereas my survey number is survey number 1 which has been known as survey number 8.
How did you get the property?
Plus, my grandfather purchased the property, and that is why the office rights have been registered in his name with respect to survey number 1. He has been granted the survey number 8, but
You also had filed an application.
he had filed 8, but
Allah, Nimma grandfather. You also had filed an application. Huh? There is an order passed in his favor.
two different grants.
Hmm.
After research,
Hmm.
survey number 1 has been survey number 8, and this survey number 8/3 is shown as survey number 20. But now he is containing survey number 8/3 itself is 8, and my name is shown. That is why he has challenged the order.
See, if you have a dispute regarding the identification of the property, then that cannot be questioned. You cannot challenge an order passed by the deputy commissioner under section 95. Then therefore, but then if suits are pending, not against this person. Release this matter on 25th of January 2024 to enable the learned counsel for petitioner to seek instructions from the petitioners. Full stop. It is sought to be contended at the hands of the contesting respondent that the order of conversion has been passed by the deputy commissioner in respect of the land belonging to the fifth respondent, which has got nothing to do with the lands of the petitioners. Full stop. Yes. Yalla reach agutte. Yes.
I appear for petitioner's counsel.
32 alla.
32, my lord.
Ah.
In this case, your lordship passed an order on 30th/9/2022, directing the Tahsildar to identify the land with the assistance of the survey authorities. And Tahsildar has followed the order, and a copy of that identification on 30th/9/2022, my lord. Your lordship passed a direction to the Tahsildar regarding identification of land of the petitioners and the rival contenders. And later, pursuant to your lordship's order, the Tahsildar passed forwarded the papers to the assistant director of land records, and land record assistant director has identified the property in 10/1/2023, Annexure H. Annexure H, my lord. Which I furnished on 25/2023.
You sought for amendment of what?
So amendment, that is assistant commissioner and the legal heirs of the respondent I have pleaded. But regarding the direction of this honorable court has been executed by the respondent Tahsildar.
I didn't find such an order. Which order are you talking of?
Your lordship passed order on 30th/9/2022, my lord.
30th.
30th September 2022. Pursuant to that order, based on that, Tahsildar passed an order, which is at Annexure H, my lord, which I furnished on 26th May 2023. 26th May 2023. The Annexure H dated 10/1/2023. In that, he says that ಸದರಿ ಆದೇಶದಂತೆ ಉಲ್ಲೇಖಿಸಿದ ಭೂ ದಾಖಲೆಗಳ ಸಹಾಯಕ ನಿರ್ದೇಶಕರು, page 4, my lord. He passed an order, ಸದರಿ ಆದೇಶದಂತೆ ಉಲ್ಲೇಖಿಸಿದ ಭೂ ದಾಖಲೆಗಳ ಸಹಾಯಕ ನಿರ್ದೇಶಕರಿಂದ ವರದಿ ಮತ್ತು ನಕ್ಷೆ ಪಡೆದು ಪರಿಶೀಲಿಸಲಾಗಿ ಜಾಲ ಹೋಬಳಿ ಸರ್ವೆ ನಂಬರ್ 35ರ ಹೊಸ ನಂಬರ್ 77ರ ಜಮೀನು ಅಳತೆ ಕಾರ್ಯ ನಿರ್ವಹಿಸಿ ದೃಢೀಕೃತ ನಕ್ಷೆ ಪ್ರತಿಯೊಂದಿಗೆ ವರದಿ ಸಲ್ಲಿಸುತ್ತಾರೆ. ಸದರಿ ನಕ್ಷೆಯ ಕಲಿಪ್ರತಿಯನ್ನು ಈ ಪತ್ರದೊಂದಿಗೆ ಲಗತ್ತಿಸಿ ತಮ್ಮ and the sketch had been adduced at page 5, my lord. In which my names have been entered as ಅನುಭವದಂತೆ ಹೆಸರು ಬಸವರಾಜು and ಸುಬ್ಬಣ್ಣ 2 acres. We are in the possession, and according to RTC, the respondent's name continues. But according to Anubhava and the document, we are in the possession and all these things. The mutation entries have to be followed pursuant to court order, which that respondents are not doing. That's why this I approach your lordship. Pursuant to court order, my land has been identified.
The respondents are claiming through whom?
No, through sale deed. Through sale deed.
ಅಲ್ಲಲ್ಲ, ಥ್ರೂ ಹೂಮ್ ಸರ್? ಅಲ್ಲಿ ಗೋವಿಂದ್ರ ಬಂತು, ಆಮೇಲೆ ಒಂದು ಈರಮ್ಮ ಅಂತ ಒಂದು ಬಂತು.
There was a confusion between whether this land belongs to Akkayamma or Govindra was the issue. Now the land has been identified, it belongs to Govindra. Manjuridar Govindra. From Govindra, the Subbanna and Basavaraju have purchased. That is not disputed. They were claiming our land is their land.
ಯಾರ್ದು ಅವರ್ ಲ್ಯಾಂಡ್ ಅಂತಂದ್ರೆ ಕ್ಲೈಮಿಂಗ್ ಥ್ರೂ ಹೂಮ್ ಅಂತ ಕೇಳ್ತಾ ಇದೀನಿ.
Claiming through Govindra's land was purchased by this petitioner and another person, my lord.
You are claiming from whom, sir? Through whom, sir?
Independent.
How?
Also is a grant. They are also claiming.
Who is that person who was granted?
The survey number 35 is the reservation.
Who is the person through whom you are claiming, sir? Uttama was granted land, is it? Uttama. What has that got to do with this lands granted to Govindrao? Houdri, they have purchased the property from under registered sale deed from Govindrao.
They are claiming that they have purchased the survey.
Yes.
Now the revenue record stands, all the RTCs are standing.
How?
777.
How?
I am also planning.
Therefore, we are directed the revenue authorities to find out regarding the identification. Now it is clear that the
survey is conducted without notice to us, no notice is issued. My lord, the extent of land, my lord, it is available 3 acres, they have written 4 acres. My lord, the same survey department has no tipping at all in that. That is what the endorsement is
Sir,
given.
at any rate, you are not concerned with this property. This is a land which was
I am concerned with the survey.
survey number 77, really, that was a larger extent.
No,
We are not concerned with everything. We are only concerned with the land which was granted to Sri Govind Rao.
They are coming from side. The revenue records are standing my name with respect to survey number 77.
Survey number 77, really, there is a larger extent.
No, survey number 77, there is no larger extent. Only 3 acres 4 puntas is only there.
Huh?
Survey number 77, only 3 acres 4 puntas is there.
Huh.
What they are saying, my revenue record stands in survey number 35, whereas I am possession of survey number 77. So you mutate my name in the survey number 77, deleting my name. That is what the reputation is filed. Their revenue records is produced for survey number 35. They are claiming my land. You know, they say that's in assistant revenue, they said no tipping, no other copies are available. You know, the very land available is 3 acres, their report, survey report is 4, no notice is given. While admitting the reputation, the court expressed it is an ambiguity of the question. Therefore, while admission considering, there was no direction for survey at all. And while my detail application, my land is already converted.
You purchased in survey number 35 or 3.
Yes, my lord. Yes, my lord.
Why are you now asking for survey number 77?
No, survey number 35 was a Gomala land, and survey number has been changed into, it was about a larger extent of more than 50 acres of land. The new survey numbers have been assigned to all grantees. Likewise, I was also given a new survey number, my lord.
Sir, in the sale deed,
In the my lord, yes, in the sale deed also.
of the year 1995,
Yes, my lord. At
the
page
survey
8,
number is mentioned as 35/3.
Yes, my lord. It's 35/3. My lord.
When did it become 77?
My lord, it became 77
Ah.
in the year. Kindly peruse, my lord, page number. Kindly peruse, my lord, DC's order annexure D, and also page number page number 51, my lord. Page number 51. It starts at page number 48, my lord. 47. Resurvey Tippani, annexure C, my lord. Annexure C, ಹೊಸ survey number 77. Manjuri annexure C, page 47, my lord.
Survey number 35 ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ.
35 ಪೈಕಿ 35 survey number 35 ಪೈಕಿ 77 ಕರ್ದ, my lord. And
ಇಲ್ಲ. That there is no clarity as
my page 60, my lord. DC has passed an order. In that he says that page 60, my lord. Kindly peruse page 60. Page 60 ಆದೇಶ. ಬೆಂಗಳೂರು ಅಪರ ತಾಲೂಕು ಜಾಲ ಹೋಬಳಿ ಸರ್ವೆ ನಂಬರ್ 35ರಲ್ಲಿ 4 ಎಕರೆ ಜಮೀನು ಹಿಂದೆ ಕಾನೂನು ಪ್ರಕಾರ ಗೋವಿಂದರಾವ್ ಬಿನ್ ನಂಜುಂಡರಾವ್ ಅವರಿಗೆ ಮಂಜೂರಿಯಾಗಿದ್ದು, ತಹಶೀಲ್ದಾರ್ ದೇವನಹಳ್ಳಿ ತಾಲೂಕು ತಗ್ಗು ಬೆಲೆಯನ್ನು ಮಂಜೂರುದಾರ ಪಾವತಿ ಸಾಗುವಳಿ ಚೀಟಿಯನ್ನು ನೀಡಿದ್ದು, ದಾಖಲೆಗಳು ದೇವನಹಳ್ಳಿ ತಾಲೂಕು ಕಚೇರಿ ಲಭ್ಯವಿರುತ್ತದೆ. ಮಂಜೂರಾತಿ ನಂತರ ನೋಂದಾಯಿತ ಕ್ರಯಪತ್ರದಲ್ಲಿ 1795 ಕ್ರಯಪತ್ರವಾಗಿದ್ದು, ಕಂದಾಯ ದಾಖಲೆಗಳ ಪ್ರತಿವಾದಿಗಳ ವಿರುದ್ಧ ಜಾಲ ಹೋಬಳಿ ಬೀಸ್ಕಾನಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 35/3 ರಲ್ಲಿ 2 ಎಕರೆಗೆ ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ಕಾಯ್ದೆ ಅಡಿಯಲ್ಲಿ ದಾಖಲಿತ ಪ್ರಕರಣವನ್ನು ಕೈಬಿಡಲಾಗಿದೆ. ತಹಶೀಲ್ದಾರ್ ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು ಸಂಬಂಧಪಟ್ಟ ಕಂದಾಯ ದಾಖಲೆಗಳ ಸೂಕ್ತ ದಾಖಲೆಗಳನ್ನು ನಮೂದಿಸಲು ಆದೇಶಿಸಿದೆ. ಸದರಿ ಆದೇಶದ ಒಂದು ಪ್ರತಿ ತಹಶೀಲ್ದಾರ್ ಅವರಿಗೆ ಕಳಿಸಲಾಗಿದೆ. Even special DC has passed an order in 2010-11 stating that 35/3 is 2 acres. Now what they are telling, including Kharab, it is 4 acres according to the report submitted by the authorities as per your lordship's order. 4
Adalla
acres.
sir. No. How and when this survey number 35/3 was assigned new number 77?
That copy.
Their claim is regarding survey number 77.
No, my submission is on page 47, my lord. The survey number, this survey number has been assigned.
Even in this order, there is no such reference
No.
that it was reassigned survey number 77 anta.
Resurvey tippani, my lord. This is the only document.
No, the order that you read at page number 60 doesn't say so.
ಕಂದಾಯ ದಾಖಲೆಗಳ ಪ್ರತಿವಾದಿಗಳ ವಿರುದ್ಧ ಸಾಗುವಳಿ ಚೀಟಿಯನ್ನು ಹಿಡಿದು ದಾಖಲೆಗಳು ತಾಲೂಕು ಕಚೇರಿಯಲ್ಲಿ ಲಭ್ಯವಿರುತ್ತದೆ. Based on those documents.
There is no dispute. See, if land has been granted to Mr. Govindrao and you have purchased 2 acres out of that, it may be true. There is no difficulty. But their contention is that in the guise of having the revenue entries made on the strength of the sale deed, now which was in respect of survey number 35/3, they are now seeking to come to survey number 77.
My lord, there is no grant letter in their favor also. Survey number 77, page 47, page number 5.
That is not important. You will have to satisfy this court that survey number 35/3 was later reassigned new number 77, and therefore you are legitimately entitled to have your name continued in the RTC.
Yes, my lord. Same in even the grant papers in page 41, my lord. 4 acres have been granted to me. On the contrary, there is no grant letter in their favor.
There cannot be any dispute regarding that, sir.
My lord, I will physically appear and convince your lordship of Monday date.
Learned senior counsel, Sri Divakar, appearing on behalf of the petitioner, would submit that in compliance of the directions issued by this court on 30/9/2022, ಯಾಕ್ರಿ ನೀವ್ ಹಾಕ್ಬೇಕಾಗಿತ್ತು ಅದನ್ನ ಬೈ ದಿ ಪೆಟಿಷನರ್ has filed. Where is that report? No, that's what.
Party order. The court made an observation. Based on that observation, without any direction from the court, they have voluntarily submitted, saying that there is a direction.
All right.
Endorsement that it says there is no duty of the available for survey number 77. There is no duty of the available. Question of survey does not. Objection, detailed objection.
And senior counsel Sri Divakar, appearing on behalf of the petitioner, would submit that in compliance of the direction issued by this court on 30/9/22.
Tahsildar. Has issued an endorsement dated 10/1/2023, along with the copy of extract of the tippani which has been furnished along with an application filed in IA number 1 of 2023. Stop. However, learned counsel for the contesting respondents submits that if there was a direction by this court to the revenue authorities to do a certain act, the report should have been submitted by the learned government advocate and not by the petitioners. Stop. Even otherwise, it is submitted that the contesting respondents should be permitted to file objections to such an endorsement said to have been given by the Tahsildar. Full stop. Next paragraph. Learned HCDP is directed to find out from the respondent Tahsildar as to whether the endorsement dated 10/1/2023 given to the petitioner is in compliance of the directions issued by this court. Stop. Or, if an inquiry has been conducted in terms of the directions issued by this court, then the report shall be submitted through the learned HCD. Full stop. It is only an endorsement, it's not a report. It's an endorsement, it's not a report. Anyway, you want to file objections, you file. Next para. All right. Release this matter on 31st of January. For what? Why are you seeking a change of the entries in the land records when the suit is pending consideration? You get the suit decided. Accordingly, whoever succeeds, their name will be entered. Huh? This property is not a subject matter of the suit. Huh? Who has filed the suit? Huh? Your side or their side? Huh? 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 Hmm. See, number 43 per 1 is extent of 2 acres. 42, 43 per 2 is also extent of 2 acres.
Claiming one for 2 acres, 7 for 43 for 1 month. Other 43 for 2 months.
ಎರಡು ಇದೆಯಲ್ರಿ.
47 for 2 acres in each month.
ಹೌದು.
But in this there is a partition for only 2 acres.
No, no, when the suit was pending, why are you going to the revenue authorities to seek change of mutation? ಏನಾದ್ರೂ ಆಗ್ಲಿ ರೀ, ಡ್ಯೂರಿಂಗ್ ದಿ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ದಿ ಸೂಟ್, ವೈ ಡು ಯು ವಾಂಟ್ ಟು ಗೋ ಅಂಡ್ ಆಸ್ಕ್ ದಿ ಅಥಾರಿಟೀಸ್ ಟು ಚೇಂಜ್ ದಿ ರೆವೆನ್ಯೂ ಎಂಟ್ರೀಸ್?
Petitioner was transferred to the scheduled property to another person. Petitioner was transferred to the scheduled property to that property. Some other person.
Yes, sold the property.
Mortgage to that property. And I have paid the sort of the.
ಏನು ಅರ್ಥನೇ ಆಗುತ್ತೆ ಬರ್ಕೊಳ್ಳಿ. This court, in its order dated 30/9/2022, has recorded the fact that during the pendency of the suit filed at the hands of the one of the petitioners, is he a respondent here? ಮತ್ತೆ ಅಲ್ಲ ಏನಾದ್ರೂ ಆಗ್ಲಿ, ಹೇಳ್ದಮ್ಮ.
Order dated 39/22 was recorded in Sandwood during the pendency of the suit filed at the hands of.
The suit in OS number 1930 of 2008. The contesting respondents approached the revenue authorities to change the revenue entries. Which would affect the rights or seriously prejudice the rights of the parties before the civil court. However, learned counsel for the contesting respondent submits that learned counsel for the contesting respondents seeks for a short accommodation to secure instructions and make submissions. Release this matter on 24th of January. Interim order granted earlier stands extended till the next date of hearing.
ಅದು hearing ಒಂದು ಆನ್ಲೈನ್ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ. ಅದೇ ನೀವು ಫಿಸಿಕಲ್ ಬೇಡ ಸರ್, ನೀವು ಅಲ್ಲಿ ಯಾವ್ದು ಆಗ್ತಿಲ್ಲ, ಇದು ಇದ್ದಂತಿದೆ ಸರ್, ಚಿಕ್ಕದು ಆಗ್ತಿಲ್ಲ. ಸರ್ ಎಷ್ಟೊಂದು ಮೆಮೊಸ್ ಬರ್ತಾರೆ, ಎಷ್ಟೊಂದು ಕೋರ್ಸ್ ಆಗ್ತಾರೆ, ಎಲ್ಲ ಆಗ್ತಿಲ್ಲ. ಇಲ್ಲ ಸಾಧ್ಯ ಆದ್ರೆ ಎಲ್ಲ ಒಂದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಯಾವ ಹಾಗೆ ಈಗ ದಿನ ಒಂದು ಕೋರ್ಟ್ ಹದಿನೈದರಲ್ಲಿ ಲಾಸ್ಟ್ ಕ್ಲೋಸ್ 15ರಲ್ಲಿ ಇದ್ರು
Definition ಏನಿದೆ? Focus ಕಡಿತಾ ಇರೋದು. ಆ ಕಡೆ ಏನ್ ಬೇಡ, ಅವರಿಗೆ ಕಳಿಸಿರೋದಕ್ಕೆ ಒಂದು ರೆಕಾರ್ಡ್ ಬೇಕಲ್ಲ, ಈಗ ಬಂತು ಅಂತ ಹೇಳೋದು. ಹಿಂದೆ ಬರ್ಬೇಕಲ್ಲ. ಆ ರೀತಿ ಇದೆ, ಹಾಗಾಗಿ. ಏನಿದೆ ಅಂತಲ್ಲ, ಹಾಗಾಗಿ ಇವತ್ತು ಏನಿದೆ ಮತ್ತೆ ಎಂತ ಸರ್ಚ್ ಮಾಡ್ಬೇಕು. ಈಗ ಆನ್ಲೈನ್ ನಾವು ಹುಡುಕ್ಬೇಕಂತ ನಂಬರ್ ಅವತ್ತಿಂದ ಬರ್ತಾನೆ ಇದೆ. ಲಿಮಿಟೇಷನ್ ಗೊತ್ತಿಲ್ವಲ್ಲ ಅವ್ರಿಗೆ, ಹಾಕಿ ಅಂತ ಹೇಳಿರ್ಬೋದು, ಇಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ಯಾಕೆ ಹಾಕ್ತಾ ಇದ್ರು. Number of the content. ಹಾಗೆ ಕೇಸ್ ನಂಬರ್ ಆಗಿದೆ ಕೇಸ್ ನಂಬರ್ ಅದು ನಾವು ಕೇಸ್ ನಂಬರ್ ಆಗಿದೆ One five three four of 2024. How would that be? ಎಲ್ಲ ಆಗಿದೆ.
Huh? Ah.
Moving the other part and inside of the mutating certain land of about 2 acres 35 acres of different land. But what happened was the respondent of 4 and 5, two private individuals, they filed a compromise petition in respect of a different land which we have been in possession since 1831. They intended to compromise, based on that compromise, certain limitations which we have challenged. Now, in this, earlier in 2018, the state government, which is a party, had filed a statement of objection. After going to the gravity of the matter, this on the court, by an order they said, please have a look at the order.
No, what do you want now?
No, on 21/8/2023.
No, no, for what are you mentioning now?
Yes, sir. By an order dated 21/8/2023, the state government was directed to file a fresh comprehensive statement of objection vetted by the advocate general. That has not been done. Until that is done, we may not be able to progress. It's a judicial order directing to file a comprehensive statement of objection. Please have one look, 2 lines, not that the order sheet.
No, I thought if they also know about it, and what is it? Huh? No. Is there such an order, and why there is no complaints? Huh? When was that order passed?
21/8/2023. More than 6 months ago.
Yeah, but what is this?
Taking note of the seriousness of the issue, the Lord better not that order. That it should be vetted by none other than the advocate. Earlier, prior to that, there was a direction to secure records. That is also not. An order dated 8/8/2023.
The senior counsel appearing on behalf of the petitioner. Huh?
I'm appealing as ASD. In this case, I'm appealing as ASD for you.
The senior central government counsel.
ASD.
Additional Solicitor General of India. ಈಗ ಅದನ್ನ DSG ಅಂತ ಮಾಡಿದಾರಾ?
ಇಲ್ಲ, ಅದು
Additional, ಇದು assistant.
Assistant Solicitor General is renamed as deputy. I am additional Solicitor.
Learned Additional Solicitor General of India appearing on behalf of the petitioner submits in spite of a specific direction of this court on
21/8/2023.
21/8/2023.
By a comprehensive statement of objection.
That statement of objections, a comprehensive statement of objections on behalf of the respondent state, vetted by the advocate general, learned advocate general, should be filed, the same has not been complied till date. Stop. Learned additional government advocate submits that the statement of objections, as was directed, will be filed within a period of 2 weeks from today. Stop. Accordingly, release this matter on 1st of February.
Before Nine of the agreement to indicate that Tahsildar has taken effort to start the construction in the subject land as notices from the photograph produced in the rate petition. In that view of the matter, it is the duty of Tahsildar, Mysore to see that no construction activities can be carried on in the subject land. Even if any further construction is allowed in the subject land, Tahsildar Mysore is held responsible for the same. Therefore, AG is directed to implement the Tahsildar Mysore must compliance. This is the 21. I have produced the photograph of page 21 of my application, along with the application filed for the appointment of commissioner. Application is filed on 2nd January 2024. May kindly look at the this is the order which passed on 21/12/2000.
Who is putting up the construction?
The construction is
Who is putting up the construction?
the strangers.
Huh?
They are the strangers, they are allowed to construct the encroachment. No, your lordship may kindly see, this is the order 2012.
What is the dispute? What is the matter about?
This is the dispute whether your lordship was appeared in the 2012. You may kindly take the order, page C, page 39 of the petition. But it is the dispute between regarding the petitioners and government. Their contention, it is a ULC land, you have taken possession. And our contention is page 39, Mr. C1. Page 41, relevant portion of the order. Having regard to the submission made in the last week, hearing Mr. R. Devdas, learned AGA seeks leave of the to file the affidavit narrating the position as on 30th/2012, which was that all the encroachment except for two in respect of which entry marks were pending till 30th/2012 have been removed. Mr. Agro encroachment of time. It is stated on instruction from the Tahsildar Metro Talak that the interim orders in respect of those two buildings were subsequently recalled on 30th/3/2012, and those would have also been demolished by 11 AM today. Status quo shall be maintained as of today, and the government is directed to ensure that no encroachment or unauthorized occupation takes place on any further date. For the Tahsildar Mysore Talak, who present in court, is directed to take steps for fencing the land in question. These orders remain in force till the disposal of OS number 366, 367. 366, please annexure D, it is decreed in favor of the petitioner. Against this order, they have prepared the RA. And I have asked the Tahsildar, as per annexure P1, to remove the status quo and remove the word government in column number 9 in respect of this property in survey number 155/1, what is the subject matter of the decree. And they have issued the endorsement, kindly take my letter annexure A, page 20.
It is declared that the rights of the plaintiff and possession have been protected under section 3(2) of the urban land.
Page 20.
The defendants restrained from interfering with the plaintiff's possession and enjoyment. Huh?
Endorsement put to the Tahsildar. Page 20, annexure A in the petition. This is the order is if it is ULC land, you have to protect the land. Or if it is not implementing the order, to remove the word government, they have not done it. Therefore, this honorable court passed the order to maintain status quo. That is also not being maintained. They are allowing to the strangers to put up the construction by taking bribe. Even before this article was 2023. They have
Sir,
filed
what is the prayer in the writ petition?
in the writ petition, no, that is one thing.
What's this endorsement at annexure A?
Next year is challenged.
Huh?
Next year
You,
is
you had approached the Tahsildar for what? Huh?
No,
Mutation entry. Mutation entry. Huh?
no.
In terms of the decree passed by the RA. Status filed RA. Power of attorney. Revenue sites. No. Why should the revenue authorities do all this?
The revenue authority.
It's a dispute between you and some private persons.
Their contention is it is ULC proceedings. You have acquired the property under the ULC. They have prepared the appeal. Appeal is also pending. If such a appeal is pending, the state is prepared the appeal, not pending private party. Our name, as per the decree, our name is not entered on the record.
Sorry.
So it is custody of government. It gives their what according to the annexure. If such is the case, you protect the land as per the earlier your lordship was asked the demolition earlier. Status quo was maintained by the order of 2012. The same thing is to be continued till RA is finally disposed.
Sir, if the construction is being put up by people whom your power of attorney has inducted, why should the state do all this?
That is totally incorrect. That is why even
Who are these persons then?
They are strangers. They are the encroachers.
Correct. Therefore, they are not put in by the state.
Because they are
If you have got grievance against private parties, you will have to work out your remedies before the civil court in accordance with law.
Civil court says because the record and revenue record.
ಯಾವ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಯಾವ ವಿಚಾರದಲ್ಲಿ?
ಇದೇ ವಿಚಾರದಲ್ಲಿ land revenue court, civil court.
Sir, this dispute between you and the state arises out of the Urban Land Ceiling Act.
Urban Land Ceiling Act.
That is different.
That is no urban land ceiling.
Your grievance now is some third parties are putting up construction.
Third parties construction is going on because of instance of status quo. If such is the case, why they are allowing even 2021 they have filed the affidavit. Even 21st, this still construction is going on. Construction is going on. How they have not started? It is, they have to take action. And even the authorities said they have not obtained license. They have not obtained any sanction plan to put up the construction. If such is the case.
If it is true that your power of attorney holder has
I have
done,
not taken any power of
so
attorney.
therefore, sir, in law, how can you make this prayer?
No, I have not.
We are only concerned with the claim of yours regarding revenue entry in this matter.
Revenue entries,
Ah.
because it is a state, the name is there.
Yes,
My name is not entered.
yes,
Even according to the decree.
yes.
Therefore, it is a state property till today.
Ah.
Till the appeal is disposed
So
of.
that is all. We are only concerned with the revenue entries.
Revenue entries.
We will note down their statement that since the regular appeal is pending consideration, the revenue entries are being maintained like this.
Yes, that is there.
Yes.
But during the.
ಅದನ್ನೆಲ್ಲ ಮಿಕ್ಕಿದೆಲ್ಲ ಹೆಂಗ್ ಬರುತ್ತೆ ಈ ಪೆಟಿಷನ್ ಅಲ್ಲಿ how can we consider all that?
That is considered, you are protecting the land, that is why this honorable court passed the order.
Sir, from where do you get this right to ask them, no, do all this?
No, do all this, but if they are.
We can understand if they are putting up the construction.
No,
We can say, yes, don't do it.
No, my submission is,
Yes.
I will not allow to protect the property. Because.
Why?
Because the entry is there, because the government entry is there.
So what?
No, I can't.
There is a decree in your favor.
The decree is in my favor.
Yes,
By virtue of the decree.
yes.
I have filed the execution, but the RTC records show, they have filed the appeal.
Sorry.
Appeal is pending.
So you will not get a right to protect your property?
No, appeal pending, status quo is.
Will you get right to protect your property or not?
I can't get, because unless I can't get protection because of the entry made in the government.
That has got nothing to do with the construction which is being put up by some third parties.
Third parties.
If you are aggrieved, you take action in accordance.
The state, the Tahsildar and Deputy Commissioner are defeating our claims. They are by taking.
How can you make this statement, sir?
No, that is why, my lord, they are defeating our rights. They are allowing the third parties.
What do you mean they are allowing? You can take action in accordance with law. You please take it.
No, I can't take action because it is the government state property.
We are only concerned with your claim for entering your name in the revenue records. We will dispose it off accordingly.
Revenue records are election year. What you have stated, it is ULC land.
Sir, we will simply say
No.
that although there is a judgment and decree in your favor, there is an appeal preferred by them and the matter is pending consideration. So therefore, till the disposal of the appeal, the revenue entries as it stands now will continue.
As it stands, it is
Yes,
continued.
we are only concerned with the revenue entry. In respect of the other things, you will have to work out your remedies.
Without revenue records.
There is a judgment and a decree in your favor.
The judgment and decree, that judgment and decree because of state of law is granted in RS.
Sir, that is only regarding revenue entries.
They have prepared the RA. In RA, they have obtained the status quo. In the status quo.
Status quo regarding?
Regarding position. The state is obtained.
All right,
Then the state is to maintain the status quo.
all right.
Even in the appeal also is.
That submission you will have to go and make before the court which has granted that order of status quo, that they are violating it, then it will take action.
No, even before this honorable court also, status quo is granted. This honorable court is.
Sir, we are only concerned with the revenue entries in this writ petition.
In this order
Yes.
also, I have prepared the petition before the decision bench. This 15/2022 also, the parties are directed to maintain status quo till the next date of hearing, and the same is continued.
We are only concerned with the revenue entries, sir.
No, revenue entries. But by virtue of the order, they are allowed to third parties to construct the.
That you will have to take action in accordance with law, not in this writ petition.
No, that is why madam, I have prepared the contempt petition, the visual rates of the Honorable Court, you moved it before the reference in the. Service the responsibility, seventeen, third appearance, good development, report government, trader, this. 100% minimum amount this court has taken view.
Yes.
That is why madam, it is even the order dated, status quo order dated, or the 15/12/2022, and order dated 21.
We can only say something regarding the revenue entries. We will say so.
The revenue entries. and
In respect of the physical possession, this court is not concerned.
So annexed A, it is affecting my right to protect the property. They are clearly stated. ನಮೂದಾಗಿದೆ ಸರ್ ಈ ಜಮೀನು ಯುಎಸ್ಗೆ ಭೂಸ್ವಾಧೀನವಾಗಿರುವುದರಿಂದ ಖಾತೆ ರಹ ಇರುವುದಿಲ್ಲ ಎಂಬುದನ್ನು ತಿಳಿಸಿ ನಮ್ಮ
Sir, on the basis of that, if they are doing something,
they are only doing, that is why I find application for appointment of commissioner to find out the truth.
no, that cannot be done here. We will dispose of the writ petition, asking them to maintain the revenue records, maintain status quo, even in terms of the orders passed by the regular appeal court.
What about the properties?
You will have to work out there, not here, not in this writ petition. You are saying that there is an order, there is.
I have updated this, made the application in pursuance of the decree, to please take the identities.
Other ಬಗ್ಗೆ we will consider. Only regarding that we will consider.
They gave the endorsement stating that the matter is.
Yes.
You have offered the property and the USA.
ಅಲ್ಲ ಅವರು ಅದನ್ನ ಏನ್ ಬೇಕಾದ್ರೆ ಹೇಳ್ಕೊಳ್ಳಿ. We will say, since the matter is pending consideration before the regular appellate court.
Appellate court, how can I protect the property unless the entry is made? I have filed this suit for
Therefore,
permanent injunction.
So David, please understand. If your allegation is against them,
Yes.
you go and move the regular appellate court and say they are violating the interim orders passed by this court. If some third party is doing something, even the regular appellate court will not be able to help you.
Even they are violating the orders passed by this honorable court also. This honorable court.
Sir, how could that kind of direction be issued, sir? Please tell us.
This honorable court is passed the order on 15/12/2022.
ಆಯ್ತು,
The parties are directed to maintain status quo like that.
Sir, they are not doing anything.
They are allowing the third parties.
What do you mean they are allowing? If you are claiming you are the owner of the property, you protect it then.
No,
Why should they protect it for you?
No, because I am protecting the property.
Therefore,
They are allowing.
your
They are-
cause of action will arise. Please listen. Cause of action would arise for you to proceed against them if they are doing something. That you can go and tell before the regular appellate court.
They are doing the.
If some third parties are doing something,
No.
neither can they do anything. Only you can protect yourself.
Their affidavit the affidavit filed by the Tahsildar in para 9 of their objection. I humbly submit there is no willful disobedience of the court.
Correct.
Order.
Yes.
Endorsement by the private parties. And the authorities have already initiated action against those encroachers, and the constructions have now been stalled. The photographs depicting the said stalling construction produced and marked as annexure R10-17. This is the false affidavit filed before this honorable court and misleading this honorable court, and even after filing of this affidavit, the next day the construction is still going on, allowing the third parties
ಅದೇನು allowing the third parties, allowing the, I can't understand, sir.
No, that.
ನೀವು if you are making allegation against them, we can take action against them.
That is why, that is what I am.
You are yourself saying some third parties are putting up the construction. Correct? ಯಾರ್ ಮಾಡ್ತಾ ಇದಾರೆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ನೀವೇ ಹೇಳಿ, ಯಾರ್ ಮಾಡ್ತಾ ಇದಾರೆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್? ಅವ್ರು ಮಾಡ್ತಾ ಇದಾರಾ?
ಅವರು ನಾನು ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದಿಲ್ಲಿ. Now, currently, they are collecting 10 lakhs, 15 lakhs, they are allowing the construction there. That is why I am, 10 of my affidavit, they kind of looking to that.
Which affidavit?
6% decree ಆಗಿರೋದು. 6% 25, 26% are constructed. That is why my application, the para 10 may kind of looking to. The petitioner submits the respondent number 3, Tasudar, has filed this false affidavit. 21/12/2000 in para 9 stating that constructions are stopped and thereby we mislead this honorable court. As a matter of fact, no construction is stopped.
ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ಓದ್ತಾ ಇದ್ದೀರಾ?
Para 10 of my application. Application is filed on 2nd January 2024 for appointment of commissioner. Para 10 meeting. Petitioner submits that the respondent number 3, Tasudar, has filed this false affidavit on 20th/12/2023 in para 9 stating the constructions are stopped and thereby he misled this honorable court. As a matter of fact, no construction is stopped. Still constructions are going on the instance of the respondent number 3, Tasudar. He by receiving 25 lakhs from each house, he is himself permitted that openly the land grabbers are saying in this part. In this regard, the petitioner herein made the application to the respondent number 2 and 3 along with the copies of the photographs 20th/12/2023 and he submitted to kind perusal of this honorable court at election A and L1 to C along with the CD. ಯಾರು ಬಂದಿದ್ದಾರೆ ಏನು ಅಂತ annexure K. Page 29/2023 on the deputy commissioner and Tasudar representatives. He is allowing therefore the Tasudar who filed the affidavit is already transferred immediately afterwards. And the new Tasudar is taking charge. That is my allegation. He is receiving the bribe and allowing the person. Only I have not executed any general power of attorney. How do you say that he is executed? I have executed.
Sir, please tell us what we can do in this matter.
No, my lord, either you have to change the entries in my name. Change the entries.
That is not possible because they have preferred an appeal.
Yes. If they are not changed,
Yes.
changed the
Yes.
entries. Yes. In 2012, what is the order passed by this honorable court to maintain the status quo and demolishing the construction? Then also construction was demolished in annexure C1. That status quo to be maintained. Either that status quo to be maintained by removing all structure or to enter the name.
We are not concerned with all these things.
So this is.
We are only concerned with the revenue entries.
The constructions.
All other prayer you can go and make before the first appellate court, or you will have to file a fresh suit as against that third parties who are putting up the construction.
The third party, at least the third parties who have constructed the building, I have filed this suit. Because what the court says, the RTC entries, it is a government land.
Arey, the RTC gunu construction yen sambandha. You have a judgment and decree in your favor.
No, for that purpose, I have filed the suit.
Then you work out your remedies there.
And in the suit says.
Have you stated in your affidavit that you have filed the suit?
Yes.
ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ? Why have you not stated? ಬರ್ಕೊಳ್ಳಿ. The petitioners are aggrieved of the impugned endorsement at Annexure A dated 5/12/2022 issued by the respondent Tahsildar, Mysore Taluk. Stop. Next para. It is the contention of the petitioners that they are the absolute owners of a land bearing survey number 155/1, measuring 3 acres and 13 guntas, and survey number 159/1, measuring 1 acre and 31 guntas, both situated at Hebbal village, Mysore Taluk. Stop. The land is now within the limits of the Mysore Mahanagar Palike. Stop. The competent authority under the provisions of the Urban Land Ceiling Act issued a declaration under section 6(1) of the Act sorry. It is contended that the father of the first petitioner, late Sri Sitaramya Gowda, filed a declaration under section 6(1) of the Act in the year 1976. Stop. The competent authority, that is the Deputy Commissioner, passed an order under section 10(1) and 3, holding certain portion of the land in question as excess land and forfeited the same to the government. Stop. The order of the Deputy Commissioner was challenged before the Divisional Commissioner in appeal number 11 of 1988-89. Stop. The Divisional Commissioner is said to have allowed the appeal while setting aside the order of the Deputy Commissioner. But the matter was remanded back to the Deputy Commissioner for fresh consideration. Full stop. However, in the year 1999, the Urban Land Ceiling Act was repealed by a repealing act. Full stop. It is contended that the proceedings in respect of the land in question stood abated. Full stop. However, there was interference at the hands of the revenue officials, and therefore 2 suits were instituted by the sons of Sri Sita Ramegowda, namely Sri S. Ramegowda and Sri S. Chelivegowda in OS number 366 bar 2002 and OS number 367 bar 2002. Full stop. The prayer in the suits were for a declaration of rights of the plaintiffs and for permanent injunction restraining the defendants and all persons claiming through the defendants from interfering with the peaceful possession of the suit schedule properties. Full stop.
So, there is an order, the authorities are not taking the obtained license and sanction plan. The authorities to take action under 330 notice of the corporation. In that corporation notice is challenged with no way of this granted. The corporation authority is also not able to any action. They have constructed illegally without obtaining the sanction plan. If I have given the general power of authority, that should not be constructed building without obtaining license and sanction plan. Corporation authorities.
Sir, therefore, if there is a direct allegation that they themselves are putting up the construction, we can issue direction to them, no, don't do it anta. ನೀವು ಯಾರು ಥರ್ಡ್ ಪಾರ್ಟೀಸ್ ನ ಮಾಡ್ತಾರದನ್ನ ಇಲ್ಲ ನೀವು ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡಿ ನೀವು ಡೆಮಾಲಿಷ್ ಮಾಡಿಸಿ ಅಂದ್ರೆ ವಾಟ್ ಇಸ್ ದ ಮೀನಿಂಗ್?
ನಮ್ಮ ಪ್ರಾಪರ್ಟಿನ ಸ್ಟೇಟ್ ರೆವಿನ್ಯೂ ಇಂಟ್ರೆಸ್ಟ್ ನಾವು ನಾವು ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡಬಹುದು.
It is only because of that, is it?
Because of that only.
Allah, you only if the revenue entries are made in your favor, you will go and protect the property. Otherwise, no. ನಾವೇನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? If you don't want to do it, it is up to you then.
Otherwise, they will Tahsildar is to protect it.
Why they should do it for you, sir?
They have succeeded in the revenue, RA. Once of this, if they have succeeded in the RA, what is the then the after the years the allowing to construct the building?
ಮಾಡ್ತಾರೆ, they will have to go and take possession.
After construction.
ಮಾಡ್ಕೊಂತಾರೆ. See,
25, 26 going on construction.
See, therefore, if at all some orders or directions are to be issued, it should come from the court which is hearing the regular appeal. How in these proceedings, which pertains to the revenue entries, can this court give such a direction? You please take action in accordance with law, sir.
And the directions was issued.
Status quo we can only say regarding the revenue entries.
They have filed it before the appeal, barred by mutation, and that is also not and status quo.
Anyway, you are admitting that you are already filed a suit or many suits. Go and get the requisite orders at the hands of the civil court.
No, because the court is not granting injunction because of the revenue issues in the name of government. You are not.
Sir, there is a judgmental decree in your favor. How can it be?
No, that is what the.
No. That would be wholly incorrect. That would be wholly incorrect.
That is why we have filed this application and petition.
All right, we will make that observation. If that is going to help you, you please go and place it before the court. When was that judgment and decree passed?
6 February 2021. It's a agreement. It's possible.
The two suits were decreed in favor of the plaintiffs by a judgment and decree dated 8/2/2021. Stop. Thereafter, the petitioners approached the respondent Tahsildar to make the revenue entries in their favor in terms of the declaration made by the civil court. Stop. Learned counsel submits.
And uploaded the sample report by the citizen. But the 17 people got
Ah.
that was allowed. And direction was issued by the sample report to consider this claim on the 6th of December.
ಎಲ್ಲಿದೆ ಅದು? Where is that order?
Page 87 and it said, yeah.
When the applications were not considered and no orders were passed, the petitioners herein filed WP number 17385 of 2021, seeking a direction to the respondent authorities to consider the application having regard to the judgment and decree dated 8/2/2021. Full stop. This court, by order dated 11/3/2022, disposed of the writ petition while reserving liberty to the petitioners to submit a fresh representation to the Tahsildar, Mysore Taluk with all the necessary particulars in respect of their claim. Full stop. It was directed that the Tahsildar shall examine the same and take appropriate decision in accordance with law within a period of 4 months. ಆಮೇಲೆ
We have made the application according to the.
ಈ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
This our endorsement is challenged before the sample report.
Full stop. Consequent to the directions issued by this court, after a fresh representation was given by the petitioners, the impugned endorsement dated 5/12/2022 has been issued by the respondent Tahsildar, Mysore Taluk, declining to enter the name of the petitioners in the RTC. Next para. Learned counsel for the petitioner submits that on going through the impugned endorsement, it is clear that the Tahsildar is declining to enter the name of the petitioners, not only on the ground that a regular appeal has been preferred by the state against the judgment and decrees
stated any appeal is preferred.
Huh?
Appeal is preferred ಅಂತ ಏನು ಹೇಳಿಲ್ಲ.
ಹಾ
ನಾವು ಇದು ಅಕ್ವೈರ್ ಆಗಿದೆ ULCG ಅಂತ ಹೇಳ್ತಾ ಇರೋದು. Not even stated the single word regarding you have preferred the appeal and you have obtained status for no status for is also
All right.
granted to them.
it is clear that the Tahsildar seeks to contend that the lands in question have been declared as excess land under the provisions of the Urban Land Ceiling Act, and therefore the name of the petitioners cannot be entered in the revenue records. Your name cannot be entered. Ade full stop. Next para. However, the learned AGA would submit that the petitioners are aware that the state and its authorities have preferred a regular appeal in area number ಇನ್ನೊಂದ್ಸರಿ ಹೇಳಿ. Before senior division ಅಥವಾ district court before the district court correct ಅಂದ್ರೆ senior civil judge before the senior civil judge at Mysore. Challenging the judgment and decrees passed by the trial court in OS number so and so so and so. Full stop. It is submitted that there is an interim direction. There are interim orders passed by the regular appellate court directing the parties to maintain status quo.
No such order is there.
Our submission. ಏನ್ರಿ ಇದೆಯೇನ್ರಿ
ಈ ಆರ್ಡರ್ನ ಫಾಲೋ ಮಾಡ್ತಿದ್ದ ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್ ಫಾಲೋ ಮಾಡ್ತಿದ್ದ ಅಂಡರ್ಟೇಕ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್ 39 ಯಾವ ಇದು 32-33 ಆರ್ಡರ್ ಸ್ಟೇಟಸ್ ಕೋನ ಮೇಂಟೈನ್ ಮಾಡ್ತಿದ್ವಿ ಫಾಲೋ ಮಾಡ್ತಿದ್ವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇವರು ಅಂಡರ್ಟೇಕ್ ಮಾಡ್ಕೊಂಡಿರೋದು ತಹಸೀಲ್ದಾರ್. That is why this order was issued. That is here the copies here. Tahsildar undertakes we follow the high court order.
ಆ ಲಾಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ತೆಗ್ದ್ಬಿಡಿ ಏನಂತ ಹೇಳಿದ್ರೆ
It is submitted that there is an interim orders.
ಅದಲ್ಲ ಆ ತೆಗ್ದ್ಬಿಡಿ. ಅದ್ ಮುಂಚೆ ಏನ್ ಹೇಳಿದೆ?
However, Lund would submit that the petitioners are aware that state and its authority have prepared and regular appeal in so and so before Mysore, challenging the judgment and decree passed by the trial court in OS number so and so.
Stop. Having regard to the admitted fact that regular appeals have been preferred by the state and its authorities, it would be impermissible to change the revenue entries till the matter reaches finality. We'll stop. Next para. During the course of these proceedings, several other developments have taken place. Full stop. It is sought to be contended at the hands of the petitioners that illegal constructions are being put up on the land in question. Full stop. The learned counsel for the petitioners points out to the interim orders passed by this court More particularly, interim orders dated 18/12/2023, 21/12/2023, and on top. Full stop. It is submitted that at the instance of the petitioners, this court had directed the respondent Tahsildar to file an affidavit to ensure that the property will be protected. Full stop. Pursuant to the directions, the then Tahsildar filed an affidavit dated 20/12/2023. It has been noticed in the order dated 21/12/2023 that the Tahsildar has made efforts to stop the construction, illegal constructions, stop. Learned Counsel submits that in the very same order dated 21/12/2023, it has been directed that if there is any further construction allowed on the land in question, the Tahsildar will be held responsible. We'll stop. Next para. Learned Counsel, Learned AGA submits that this writ petition is concerning the revenue entries and the statement made by the Learned AGA to the effect that since regular appeals are pending consideration, challenging the judgment and decrees passed by the civil court in favor of the petitioners, the revenue entries should be maintained as they are till the matter reaches finality. Full stop. However, insofar as the illegal constructions that are being made as alleged by the petitioners, it is clearly submitted by the Learned AGA that the respondent authorities, the respondent revenue authorities are not putting up the construction, and if some third parties are seeking to put up construction, then appropriate action will have to be initiated against such persons and not against the revenue authorities. Full stop. Next para. There is substance in the contention of the Learned AGA. Full stop. In this writ petition, we are only concerned with the revenue entries and the challenge raised by the petitioners insofar as the revenue entries are concerned. Full stop. Even if the Tahsildar has made any other statement in the impugned endorsement touching upon the rights of the petitioners, that will not have any legal sanctity. Full stop. It is undisputed that the petitioners have obtained a judgment and decree at the hands of the competent civil court in OS number so and so so and so. Full stop. Therefore, if some third parties are seeking to put up construction on the land in question, then appropriate action will have to be initiated against such persons. Full stop. Next para. At this juncture, Learned Counsel for the petitioners admits that suits have been filed by the petitioners against such third parties who are trying to put up construction on the land in question. Full stop. If that is so, the petitioners may obtain appropriate orders protecting their rights and an injunction restraining such unauthorized persons from putting up construction on the land in question. Full stop. Such applications filed at the hands of the petitioners cannot be rejected only on the ground that their names are not found in the land revenue records. Full stop. The court, which is considering the subsequent suits and such applications seeking interim orders, should take note of the fact that a judgment and decree has been passed by the competent civil court, declaring the plaintiffs therein as the lawful owners of the land in question. Full stop. Next para. Insofar as the revenue entries are concerned, it is hereby directed that the revenue entries shall be maintained as they are as on the date of the judgment and decree passed by the civil court in OS number so and so till the disposal of the regular appeals in RAS number so and so. Full stop. ಅದೇ ಅದಾದ್ಮೇಲೆ we did not say all that now itself.
That time we lose the entire property because they are allowing the third party.
Sir, why should they allow? It is for you to protect. Now we have made it clear that
Because of the annexation A, endorsement, they are saying this is to avoid way, subject to the result of the RDA.
if you have not heard what I have dictated, it's very difficult. We have said if the Tahsildar has said so many things, it has got no legal sanctity. There is a judgment and decree in your favor, adunu helidini. The court has to take note of that antanu helidini. It should not go merely on the basis of the revenue entry. Yes. Huh? ಬರ್ಲಿಲ್ವಾ ಸ್ಟ್ಯಾಂಡ್ಸ್ ಡಿಸ್ಪೋಸ್ ಆಫ್ ಬರ್ಲಿಲ್ವಾ ದಿ ರಿಟ್ ಪಿಟಿಷನ್ ಇಸ್ ಅಕಾರ್ಡಿಂಗ್ಲಿ ಡಿಸ್ಪೋಸ್. Yes. Huh? $53 ಯಾವಾಗ? ನಾವು ಆರ್ಡರ್ಸ್ ಪಾಸ್ ಮಾಡಿದ್ವಿ ನೋಡಮ್ಮ, ಫಾರ್ಮ್ ನಂಬರ್ 53. ಅದೇ ಸೇಮ್ ಆರ್ಡರ್. Yes, disposed of.
36. With Tanal. 36.
Yes. Huh?
In this one. This portion, the order is on page 6 now. Taxes interest. The short grievance of the petitioner is as to longevity of the execution process involving implementation of orders of the Karnataka regulatory authority. None of counsel for the petitioner suggests that the implementation of those orders cannot be a 5-year plan
as it has to be accomplished in accordance with the intent of Parliament in enacting the Real Estate Regulation and Development Act. Learned AGA, appearing for the respondent, opposes the petition containing that already the process for implementation is set out initiated, and that would take by its very nature some long period, and that its accomplishment, no assurance can be given as to within what period the same would be done. This is very difficult to countenance, at least as concession to the shortness of human life. The matters of this kind should be accomplished on a what way? Should the property be available? If no property avails, the question of implementation would not arise. In view of the above, the writ petition is allowed in part. Respondents number 1 and 2 are directed to accomplish implementation of subject rera orders and report compliance to Registrar General of this court within an outer limit of 3 months, in which heavy costs personally payable may be levied on an appropriate application. My lord, this particular writ petition, the recovery certificate was issued by rera, and it was issued to the deputy commissioner to recover the. They failed to perform their statutory duty. A legal notice was caused by the petitioner. Despite receipt of that legal notice, the Tesla, DC have failed to perform their statute. Therefore, this writ is filed. My prayer is.
Which statutory duty? Which statutory duty?
Under the Karnataka Land Revenue Act, my lord.
Please point out to the provision. Let us see.
Now, under the RERA Act.
Sir, it arises under the RERA Act. That is why this question was posed to you. This judgment, this order has not gone into that issue. Yes, yes. So therefore, it doesn't answer that question. That question was never raised, so therefore it was not answered. This court cannot become an executing court for the orders of the RERA. To whom? Under which provision? It doesn't arise under the provisions of the Karnataka Land Revenue Act. It arises out of the provisions of the RERA Act. At best, you want to go get an order, it should be a matter listed in the GM category. This does not arise under the Karnataka Land Revenue Act, and you are required to arraign the RERA as a party responding to the proceedings, because direction should be given to RERA, not to the revenue authorities. Huh? Then we will send it.
They are how this matter is come before my lord.
So you want this to be reclassified as GM and send it before that court? You will go there. Yes. Barkali. The issue arises out of the provisions of Karnataka Real Estate Regulatory Act. And therefore, the petition is to be classified the Real Estate Regulation and Development Clause Act, 2016, and therefore the matter is to be classified as GM. Full stop. Office is directed to reclassify the same as GM and place it before the bench having roster. Yes. I can't give the date. Huh? there are two sets of applications to bring on record the legal representatives of respond number 6 and respond number 8. Huh? 9. 3 of 2023. Notices are not ordered on these applications. Huh? Respond number 6. Ordered. Huh? ಸರ್ವ್ ಆಗಿಲ್ವಾ? ಸರ್ವ್ ಆಗಿಲ್ಲ. ಬಟ್ ಇಲ್ಲಿ ಸರ್ವ್ ಆಗಿದೆ ಅಂತ ಬಂದಿಲ್ಲ ನೋಡಿ, ಚೆಕ್ ಮಾಡ್ರಿ. ನೋಟಿಸಸ್ ಸೆಂಟ್ ಟು IS number 1 to 3 of 2019, ಆಮೇಲೆ 4 to 6 of 2019 ಎರಡು IAS ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿದೆಯಾ ಇಲ್ವಾ ನೋಡಿ, ಚೆಕ್ ಮಾಡಿ. What about that 2023 application? Not, Allah, it is not ordered. Not ordered. Issue notice. The proposed respondents on IA number 1 of 2023. Serve agilla. Then you will have to take fresh steps. Fresh steps have to be taken even in respect of IAS number 1 to 3 of 2019 and 4 to 6 of 2019. Full stop. A week's time is granted at the request of learned counsel for petitioner to do the needful. Yes. Interim order granted earlier stands extended till next date of hearing. Notary extend agide notary. ಆಗಿಲ್ಲ. ಇಲ್ಲ ತೆಗ್ದಿರ. Yes. Yes. So CM Jagdish. Matters called out. There is no representation for the contesting respondents. So release this matter on 24th of January. ಇವಾಗ ಏನ್ ಪಾಸ್ ಅವರ್ರಿ? ಇವಾಗ ಪಾಸ್ ಓವರ್ ಮಾಡಕ್ ಆಗಲ್ರಿ. ಇನ್ನು ಅರ್ಧ ಗಂಟೆ ಲೆಫ್ಟ್ ರೈಸ್ ನಾವು. Despite the directions of this court given on 9/1/2024 that the learned counsels are required to argue the matter for final disposal, there is no representation for the contesting respondents, the private respondents. Full stop. Release this matter on 24th of January. Full stop. If there is no representation for the private respondents, this court will hear the learned counsel for the petitioners and proceed to pass orders. Matter is called out. There is no representation for the petitioner. Release this matter on 24th of January. All right, all right.
I want only style my friend was stating the indictment, which I need to
Learned AGS submits that he has received copies of the writ petition. Full stop. Next para. However, at the request of learned counsel for the petitioner, release this matter on 24th of January. On 1st of February. Final hearing. Rajeshwara PN. 2009 matter. The date given matter, sir. At the request of learned counsel, Sri Rajeshwara PN, appearing on behalf of the contesting respondents, released this matter on 24th of January.
Ramesh?
Matter is called out. There is no representation for the petitioner. Release this matter on 24th of January. And what are these batch matters? Cancellation of revenue entry. You know? No, I want to know what is the matter about. ಹಾ ಹ್ಮ್ ಹಾ ಹ್ಮ್
Based on the particular report, within 3 days, it has cancelled the entire revenue increase in the file. So, we must give notice.
revenue entries. Lands were granted.
Cancelled and where the name of the state.
When was it granted? Ah, ah,
RTC entry also continuing in there.
Ah.
Based on the particular report dated 3/3/2018, the assistant commissioner has passed the order on 6/3/2018. in 3 days.
ಯಾವ್ದು ನಿಮ್ದು ರಿಟ್ ಪಿಟಿಷನ್? ಇದ್ರಲ್ಲೂ ಸಿಗುತ್ತಲ್ವಾ? ಸೇಮ್ ಆರ್ಡರ್ಸ್ ಅಲ್ವಾ? ಯಾವ್ದದು? ಅಲ್ಲ ಅನೆಕ್ಷರ್ ಅಲ್ಲ, ಬಟ್ ಡೇಟ್ when it was passed.
(6/3/2018).
10/1/2018 mutation entry made by the Tahsildar.
Sir has forwarded the report to the assistant commissioner. Based on that, they have passed the assistant commissioner has passed the order in RRT PCR 551 for 17.
This person, fourth petitioner, purchased the property. Shamji Shivji Patel, and revenue entries were made in the year 2018.
All revenue entries has been cancelled.
Ah. Notice was given under section 94 and 104. ಏನಂತ? ಸರ್ಕಾರಿ ಜಮೀನು ಒತ್ತುವರಿದಾರರ ವಿರುದ್ಧ ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ಕಾಯ್ದೆ 192 ರಂತೆ ಕ್ರಮ ಜರುಗಿಸುವ ಮುನ್ನ ಒತ್ತುವರಿನ ಗ್ರಾಂಟ್ಸ್ ಆಗಿದೆ ಅಂತಾರೆ, and their names are entered in the land records.
That notice was issued in 2015.
Ah.
They have submitted our reply. Thereafter, the Tahsildar has not taken any steps. All of a sudden, in 2018, the Tahsildar has submitted a report to the assistant commissioner on 3/3/2018. Containing that these lands are Gomala land and the revenue entries which are in the name of the parties has to be cancelled. Assistant commissioner, without conducting any inquiry, without issuing notice to the parties, he has ordered for cancel. Within 3 days from the date of report, he has passed the order.
ಯಾವ್ದ್ರಿ ನೋಡ್ರಿ ರಿಟ್ ಪಿಟಿಷನ್ ತಕ್ಕೊಡ್ರಿ ರಿಟ್ ಪಿಟಿಷನ್ ಹೇಳಿ, ಅನೆಕ್ಷರ್ಸ್ ಹೇಳಿ ನೀವು. The order of the Tahsildar is at page number 58. 2017.
He said that the revenue entries mailorder kind of that is not name. Next page
ಸರ್ವೆ ನಂಬರ್ 74 ಮೂಲತಃ ಸರ್ಕಾರಿ ಗೋಮಾಳದ ಜಮೀನಾಗಿದ್ದು ಆಕಾರ ಬಂದಂತೆ ಒಟ್ಟು 207 ಎಕರೆ 9 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣವಿದ್ದು ಸದರಿ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪಾಣಿಯಲ್ಲಿ ಎಲ್ಲಾ ಖಾತೆದಾರರಿಗೂ ತಹಸೀಲ್ದಾರ್ ಬೆಂಗಳೂರು ಪೂರ್ವ ತಾಲೂಕು ತಪ್ಪು ಸಾಬೀತುಪಡಿಸಲು ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸುವಂತೆ ಸೂಚಿಸಿ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಲಾಗಿರುತ್ತೆ.
According to that notice, we have already declared.
ಹಾ,
That is also there is more reference regarding that.
ಸದರಿ ಪ್ರಸ್ತಾವನೆ ಪಟ್ಟಿಯಲ್ಲಿ ಕ್ರಮ ಸಂಖ್ಯೆ 6, 5, 6, 10 ಖಾತೆದಾರರ ಪೈಕಿ 5, 6, 10 ಖಾತೆದಾರರಿಗೆ ಮಂಜೂರಾದ ಜಮೀನು ಓಡಿ ದುರಸ್ತಿಯಾಗಿ ಕ್ರಮವಾಗಿ ಹೊಸ ನಂಬರ್ 109, 126, 136 ಆಗಿರುತ್ತದೆಂದು ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಹಾಗೂ ಸರ್ವೆ ನಂಬರ್ 74P12, 13, 18 ಪಹಣಿಯಲ್ಲಿಯೂ ಸಹ ಖಾತೆದಾರರ ಹೆಸರು ಮುಂದುವರೆತಿರುವ ಕಾರಣ ಸದರಿ ಪೈಕಿ ಪಹಣಿಯನ್ನು ರದ್ದುಪಡಿಸಲು ಉಲ್ಲೇಖದ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ಕೋರಿರುತ್ತಾರೆ. ಎಲ್ಲಿ ಜಾಗ ಇದು? ಹ, ಅದೂರು. ಹ, ಹ,
ಪುಸ್ತಕ 4 ಬಿಟ್ಟು ಬಾಕಿ ಎಲ್ಲವನ್ನೂ ನಾವು ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ತೀವಿ ಅಂತ ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ.
ಹ,
Not this part of 63/2018.
yes, without giving opportunity. So you questioned the same before the deputy commissioner.
We have direct because thereafter, that is matter was referred to the chief commissioner. And government, as per the annexure 3, they is supposed to allot these land to the several institutions. As per annexure 3. ಇಲ್ಲ ಸಂಘ ಸಂಸ್ಥೆಗಳಿಗೆ ಭಾಗ 1 ಮತ್ತು 2 ಪ್ರಕಾರ allotment ಮಾಡಬೇಕು. Page number 78. Para 20 days, everything has been completed.
Two 2018, 26/3/2018.
6/3/2018 की RTC entry cancel हो गया था. 26/12 के मध्य report करता है
This your challenge.
Regarding the revenue entry, they have to issue notice and conduct the inquiry. And then you have to pass it. Moreover, the revenue records, all these documents show that we are continuing to.
We are not concerned with your possession, sir. If there is no records, original records, that would evidence the factum of grant. Not what you produce. We'll have to direct the deputy commissioner to summon the original records, verify them in your presence. You will also be satisfied. Yes, it has been looked into. There is no entry. If there is no entry, then you will have no claim. That is the end of it. All these matters, same thing. ಆಯ್ತು ತರ್ಸಿ ಬರ್ಕೊಳ್ಳಿ. Since it is the claim of the petitioners that the respective parcels of land were granted to them way back in the year 1962. And therefore, and on the strength of which revenue entries were also maintained by the respondent authorities. And therefore, they could not have, the deputy commissioner could not have granted the same lands to any other party or institution, the original grant register and issue register of the relevant year are required to be looked into. Full stop. Next para. The learned AGA is directed to secure the original grant register and issue register of the relevant years and place it before this court on the next date of hearing. Full stop. Release this matter on 29th of January. Yes. It's a date given matter. Huh? It had come up last week. Week before that. ಏನ್ರಿ ಅದು ಶಾರ್ಟ್ ಅಕಾಮಿಡೇಷನ್ ಅಂದ್ರೆ ಅರ್ಥ ಡೇಟ್ ಕೊಟ್ಟ ಮೇಲೆ ಬರ್ಬೇಕು ತಾನೆ
The assistant commissioner and deputy commissioner are concurrently held in my paper. The suit that is instituted by him that is pending. The commissioner says subject to the decision in the suit, if it gets changed, it gets changed. 1994-95 it is in my name.
ಇವಾಗ ಹೆಂಗೆ ಸೂಟ್ when suit is pending consideration, how can you seek a change in the revenue entries? At the request of learned counsel for petitioner, release this matter. Can we have it on Saturday? On 22nd of January. Huh? When was it granted? Interim order granted earlier stands extended till the next date.
Was granted on 17/2/2004. Subsequently, has initiated a appeal for the assistant.
2017 ಅಲ್ಲಿ
That order also has been considered and the assistant commissioner at page 79 annexure D has come to a definite conclusion that the committee has already granted the Therefore, he had to do in accordance with that direction has been issued in my case. Has not been done in spite of my representation. Page 18 again.
ಅಲ್ಲಲ್ಲ proceedings are initiated under rule 108K. ಅಲ್ಲಿ 6 ಅಂತ ಹಾಕಿದ್ದಾರೆ seeking cancellation of the grant. So it has to be 108K.
That can be available by the Petitioner or if it is rejected by the applicant.
ಆಯ್ತು.
So the appeal that has been filed, not 18 is correct. That has been rejected by the.
ಪುರಸ್ಕರಿಸಿದೆ ಅಂತ ಬರೆದಿದ್ದಾರೆ ಮತ್ತೆ
ಪುರಸ್ಕರಿಸಿಲ್ಲ ಅದು. Technically it is legally with respect to subject the appeal is dismissed because kindly see the order.
ಈಗಾಗಲೇ ಅರ್ಜಿದಾರರಿಗೆ ಜಮೀನು ಮಂಜೂರು ಮಾಡಿ 13 ವರ್ಷಗಳು ಕಳೆದಿರುತ್ತದೆ. ತಹಲ್ವರೆಗೂ ಜಮೀನು ಮಂಜೂರಾತಿಯ ನಂತರ ಮಂಜೂರಾತಿ ನಿಯಮಗಳಡಿ ಕ್ರಮ ಕೈಗೊಂಡಿರುವುದು ಕಂಡುಬರುವುದಿಲ್ಲ. ಆದ ಕಾರಣ ಬಗರುಕುಂ ಸಕ್ರಮ ಸಮಿತಿ ನಡವಳಿಕೆಯಂತೆ ನಿಯಮಾನುಸಾರ ಸೂಕ್ತ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಆದೇಶಿಸಿದೆ. It was not your representation. It was an appeal preferred by the Tahsildar.
Subsequent to the AC's order,
Ah.
I made a representation. I made a representation annexed E,
Seeking
to act in accordance with the.
issue of ಸಾಗುವಳಿ ಚಿಟ್ ಇನ್ನು ಮಾಡಿಲ್ಲ ಅಂತನಾ? So you are seeking directions. You are seeking direction for issuance of ಸಾಗುವಳಿ ಚಿಟ್.
ಬೇರೆಯವರು ಮಾಡಿದ್ದಾರೆ, 4 ಜನಕ್ಕೆ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. 4 ಜನಕ್ಕೆ ಮಾಡಿ ನಮ್ಮ 13 ಜನಕ್ಕೆ ರಿಫ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. ಅದರ ಮೇಲೆ ಅಪೀಲ್ ಹೋಗಿ.
ಚಿಕ್ಕಪುಟ್ಟಯ್ಯನ ಪಾಳ್ಯ, ಕಸಬಾ ಹೋಬಳಿ, ನೆಲಮಂಗಲ ತಾಲೂಕು.
ಚಿಕ್ಕಮಾರನಹಳ್ಳಿ.
ಚಿಕ್ಕಮಾರನಹಳ್ಳಿ.
Typed copy is at 82.
Yes. Yes, Mr. Regie. We'll issue directions. Berkeley. The petitioners claim to have been granted various parcels of land as per the decision of the Committee for Regularization of Unauthorized Occupation, which allowed the applications filed by the petitioners in form number 53 seeking regularization of unauthorized occupation, by order dated 17/2/2004. Stop. However, till date, the Sagoli chits are not issued, and therefore the prayer in the writ petition is to direct the respondent authorities, more particularly the Tahsildar, to consider the representations given by the petitioners for issuance of grant certificate for Sagoli chits. Full stop. Next para. It has been pointed out by the learned counsel for petitioner that long after the committee passed a resolution on 17/2/2004, the Tahsildar, Nelmangla Taluk, preferred an appeal under rule 108(6) of the Karnataka Land Revenue Rules, challenging the resolution passed by the committee before the Assistant Commissioner, Dodballapura Subdivision. Full stop. The Assistant Commissioner, having been satisfied that there is no merit in the appeal filed by the Tahsildar, directed by order dated 23/10/2017 that the Tahsildar is required to take action in terms of the resolution passed by the committee. Full stop. Learned counsel submits that after the orders were passed by the Assistant Commissioner, several representations have been given by the petitioners seeking compliance of the directions issued by the Assistant Commissioner and sought for issuance of grant certificate bar Sagoli chits. Stop. Next para. Having regard to the material available on record, it is clear that the factum of grant made in favor of the petitioners cannot be disputed at the hands of the respondent authorities. More so because an appeal was in fact preferred by the Tahsildar seeking to set aside the resolution passed by the committee. The Assistant Commissioner has held that the resolution passed by the committee to grant the lands in favor of the petitioners is in accordance with law. Consequently, the writ petition stands disposed of with a specific direction to the third respondent, Tahsildar, Nelamangala Taluk, to comply with the directions issued by the Assistant Commissioner. In LND RUC bracket A 53 of 2016-17 dated 23/10/2017 at annexure D, which is an appeal preferred by the Tahsildar. Stop. The Tahsildar shall complete the exercise of issuance of grant certificate bar Sagoli chits to the petitioners in terms of the resolution passed by the Committee for Regularization of Unauthorized Occupation on 17/2/2004, as expeditiously as possible and at any rate within a period of 4 months from the date of receipt of a copy of this order. Stop. Ordered accordingly. ಅದು ಬರೋದಿಲ್ವಲ್ಲ ಅಲ್ಲಿ those were cases where the applications were not considered at all. No orders were passed. ಅದೇನೆ
Third person fights a petition. Third person petition for the instant coming. Accepts the version and changes the revenue rating from the name of the original owner to the name of one Darga. Darga is also property of the petition. But simultaneously followed by which not feeling agreed with the petition of appeal of filed before the Deputy Commissioner. Deputy Commissioner takes a view that in view of pendency of the proceeding, I cannot change it.
which proceedings?
There is a declaration suit filed by the petitioner in the year 1998, which is still pending. In which the original parties against the rival parties, the suit is pending. These persons are the petitioner in the revision petition before the Assistant Commissioner and for the respondent in the Deputy Commissioner proceeding. But totally stranger.
When was the order passed by the Assistant Commissioner?
Assistant Commissioner order is that page number 55, annexure K. Right. 24th July 2018.
And you have filed the suit in the year 1998.
I have filed this suit in 1998. But in 1992 itself, I had filed a petition before the Assistant Commissioner seeking to register the khata in my name to an extent of total 8 acres. So that was rejected, against which immediately I filed a suit for declaration of title. In the year 19% acquiring the property of 8 acres in the year 1991.
How did you acquire?
By registered statement. Pursuant to which I applied for change of khata in my name for extent of 8 acres. So the Assistant Commissioner at that point of time reminded the matter to Tahsildar to reconsider my request and to do needful as per the occupation or position of the court. But that order that was considered with the Tahsildar in year 2016. Accordingly, my lord, he has assigned 33 guntas in my name, and during the sixth term, I had sold one portion 4 acre 23 guntas. It was registered in the name of purchaser. Remaining extent is to be my name. This 33 guntas was registered in my name with sub number as 35 articles. But this in the year 2018, Assistant Commissioner at the instance of a third party, he allows the petition and he reregisters the khata in the name of Dadi. Worship may kindly will find the order of the Assistant Commissioner annexure A. Before that, your worship may kindly see the proceedings which I have initiated. It is at annexure D, page number 33.
Oh, you yourself have executed a sale deed?
Yes, I have executed in respect of 4 acre 23 guntas in respect
No,
of
no, no,
Mandala.
not that.
No, here this is the misconception or misconceived by the assistant commissioner at para number 2. This sale deed is not with regard to this 33 guntas, it is with regard to 4 acre 23 guntas which I have sold. Your lordship will find the sale deed at annexure A.
In favor of one Allah Baksh.
She is the owner of 4 acre 23 guntas, and your lordship may kindly, your lordship will also find the revenue entry as per annexure.
And you made the same submission before the deputy commissioner.
All those things, Lord, the assistant commissioner holds that since Dargah is in existence, I will register the revenue and I will register the money in the name of Dargah. Dargah is my own land, Lord. I have left for my family religious purposes. I have earmarked certain extent in that particular of my land. But this was never bifurcated at any point of time. All along 33 guntas was continued in my land, Lord. Annexure F says about all these things, not annexures, the revenue entry that has been made in my name as well as in the name of my purchase, the subsequent purchase are not 4 acre 23.
Who is appearing for the contesting respondent? It's a yes, Sampath. Matter is called out. There is no representation for the contesting respondent number 4. Release this matter on 22nd of January. All of the matters next week. Huh? Huh? It's in the B group now. Bharat, next week, Bharat. Let us see. I am not going to give any dates. Who's there on the other side? You are 22nd. That was serial number. All right. Reach ಆಗಿಲ್ದಿರ ಅದನ್ನ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಯಾಕೆ ಕೇಳ್ತೀರಾ?
Court officer? Court officer? Court officer?
ಎಸ್ ಮೇಡಮ್ ಕೇಳಿಸ್ತಿದ್ಯಾ?
Sir, serial number 52
next week ಮೇಡಮ್ ಅವರೇ.
next week, huh? Was not called out or?
Not reached.
Ah, okay, fine. Thank you, sir. Thank you.